Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you and what happened? My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging hoe who planned it from the beginning point. She had mountains of evidence of her contribution to dad's company and running the private estate. Expense reports, receipts, dates, and times her and dad proved their relationship with trips and combined spending etc. She had so much evidence, the judge took 4 days to look it all over, after which he came back and basically said, why the hell would you have all of this if this wasn't your plan the whole time? The case was very downhill from their point. Edit. Jesus Christ, we pinball. Okay, some more clarification point. She'd done the same thing to her ex-husband, giving precedent. He and her children said so in their testimonies. One of her children even inadvertently admitted she'd told them what to say and paid them for it. We were able to name the date the relationship between her and my dad ended, which was months before she claimed, and outside the time limit, to make it a de facto / common law marriage. Point. We had testimony from the doctor at his ICU who said she tried to keep everyone, including his ex-wife, our mother, and us, his children, away from him. Meanwhile she had his phone and computer, and was trying to take over his contacts and business. We had proof of this. Her lawyer was a moron who constantly contradicted himself and the evidence. He lost documents, gave incorrect dates, and asked irrelevant questions of the defense. Point. In the end, it was that her expenses for the relationship were deemed normal for anyone in any kind of romantic relationship, that gifts and meals aren't claimable for compensation, that her contributions to the household and business were not sufficient to warrant compensation. She never actually put any money into either, and that the relationship was not sufficient in duration to qualify as a common law marriage. Point. This case took 4 fucking years to settle, including 2 elevations of appeals. She finally gave up because she'd run into about $250,000 of court fee debt, as well as being forced to pay us $40,000. Not a lawyer, but took my bill's landlord to small claims court. He's on SSI, and I'm his conservator. We sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. Point. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not okay. He did, and that's why she kicked him out. Point. I'm very organized and presented the judge with a folder containing photos, receipts, short videos on DVD and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for, claiming that the apartment was trashed. There were holes in the walls, and they would have to repair everything before being able to rent again. Point. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my Bill's apartment obviously still being lived in. His stuff was all still there, and no visible damage, but there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where is the damage?" The son replied, "You can't see it. It's behind all of the posters." The judge frowned and looked at the video again, and then said, "Did you take this video when he was still living there at this time?" The son replied, "Yes." This was the clincher. The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. Point. We were awarded the full amount. I'm not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual, but the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry, did you mean carbon monoxide?" Because that's a completely different thing. Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book point edit. For clarification, this is not the only reason that lawyer didn't win. There were a lot of other things that didn't work out in his favor, but those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor, but it worked against him because he made a basic chemistry mistake that he honestly should have caught. Yeah, I know, he's not a scientist, but you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. Actual lawyer here, and this one was especially sweet. Point was involved in an ownership/control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified, and drafted a motion explaining to the court how these orders from Venezuela work, and how they are in effect the highest law of the land, which meant the case should be over, and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company, but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order edited for spelling. Prepping for rhymer has left me unable to spell, and to add the following, some background. The original Venezuelan High Court order, first order, created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States against an American company. The receivership was put in place by the shareholders and the Venezuelan government as the owner of the Venezuelan company. Douchebag was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claim to the federal court here in Miami that they were the only ones representing the company and that we were the imposters. They argued that the first order was not valid and Douchebag was still in control of the company. There was a second order was the result of an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. Douchebag and his attorneys submitted the first and second order as support to their motion. A third order was issued by a different Venezuelan appeals court which put the issue to rest. We asked for and received a copy of it. They did not either, because they knew it was not supportive of their position, or because they dropped the ball. We believed it to be the latter. Our motions cited similar case law and advanced the same positions, but were interpreting different orders. TLDR, we did our homework, they didn't. Bonus TLDR, Venezuelan courts are whack. A guy I used to work with was going through a messy divorce about 20 years ago now. His soon-to-be ex-wife was a psycho and her father was a psychologist, so he was pulling all of the strings. Even had my coworker arrested at work one day, BS charges. The divorce case took years, one young son involved, and at every turn, my friend lost, because of something the father filed, or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed, and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case, and she said yes. The judge turned to my friend and said, paraphrasing, Mr. XXX, all these years and all these claims that I ruled against you, the court profusely apologizes. I did not believe you, but now I do. Ruling in your favor, bangs the gavel. I grant you full legal and physical custody of your minor child. Bailiff, please handcuff Miss XXX. My buddy was stunned that he won, and happy at the same time. He later found out that the note said, give me my son or I'll fucking kill you. Obligatory anal, but I'm a certified paralegal. I went to court and spoke for a friend at a hearing. I can ask questions to both parties and address the judge. The only thing I can't do is object to the other lawyer's line of questioning. So here's what happened. Best male friend was fighting a restraining order against him by his crazy ex-girlfriend. Everyone was in the courtroom that day, including her. Her lawyer questioned my boyfriend about their relationship. As an aside, they lived together. He moved out and got his own place, but they were still together. She just got obsessively crazier to the point where they broke up. She wanted some stuff back that she gifted him, and he refused to let her in while not home to get it. She got crazy angry and made a scene in his front yard, getting cops called and the neighbor's dog taken for being a pit bull in a park where they were not allowed. Bullshit, I know. Next thing you know, she's got a restraining order on his mom, who lived right next door to her son, and is trying to get one on him and sue him for his sheet back. So when he's on the stand, I'm questioning him about the incident about her showing up and trying to break in. His mother called him the moment she saw her banging on the door, so he beat the police there. She had gotten in and was in the living room. I asked him if he was in fear of her, and he says absolutely, because upon waking in, she slid an iron bar from her sweatshirt sleeve, telling him to back off. He was just standing there, mouth open wide and shocked. Cue her turn on the stand. I asked her about the day, if she had gotten in. She insisted she did via a key, which we knew was a lie. She never had a key. So then I asked her about the iron bar. Why did you have it? Where did it come from? My cop friend gave it to me to protect myself while driving from road rage. It's in my car all the time, so I just brought it with me in case anyone was inside that wanted to mess with me. And did you have it up your sleeve? Yeah. Cause I didn't want neighbors to think I was breaking stuff. She was bawling and slamming her fists into her thighs and pulling her own hair, wailing. I arrested after that. She admitted to trespassing while carrying a concealed weapon. Both restraining orders rescinded. She was asked to stay after court was adjourned, and the judge handed her mandatory therapy and committed her for observation. Fuck you, Shauna. Edit. Major thanks to you/dear_occupant. He's helped with the law for all. If you're suspicious, idiocies. Not a lawyer, but I'm a former insurance fraud investigator. We were at a hearing before the WCB. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem, for me, was that the video didn't get a clear face shot. Normally what we like to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing point. So the company lawyer is prepping me and basically letting me know to be on point, because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer, since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused as it was beyond the scope of my work, and he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated numerous times and under oath that he cannot work. Whether he's doing it for free, for cash or for fun has no bearing on the fact that he's doing roofing work while collecting compensation benefits which he was awarded because he couldn't do roofing work. The guy lost and had to repay a bunch of benefits. After a few of those hearings, I began formulating a list of lawyers I would never hire and ones I would absolutely want on my side. Ooh, I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for all of the money. The dude showed up with a mountain of evidence. Hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished this stuff like a bat before court. My parents' lawyer thought he had a good case. Until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client. "You said that was their tree." Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well. Edit. I'll obviously, but neither are most of these commenters, so I thought it was alright. Parents were being sued by their landlord, and parents had a countersuit against him. Parents were moving across country and found this house to rent. They did a walkthrough. Looks great. Landlord wants first last, security and $1,500 because they had a dog and 2 cats. Fine. It was somewhere in the $8,000-9,000 range. No big deal for them. They are set to move in on a Monday, so my mom flies in on Saturday to do one final look over, sign the contract, and get the key. Perfect. They are now the tenants. Monday, they arrive and the house is faking trashed. The landlord has moved a bunch of his stuff into the garage, shed, and one of the bedrooms. There's shit in the toilet, piss on the floor, garbage laying everywhere, used condoms. I can't really do this justice, but my mom took pictures and videos throughout the entire house. She calls the landlord and tells him that they are not moving in with the house in this condition. He tells her to clean the house, and he'll buy the first tank of oil for the house. It was empty. He tells her to do it, or he's keeping all the money for breach of contract. A lot of back and forth happens, and tons of harassing texts and phone calls from him. Court day comes, and everyone's ready to submit their evidence in front of the judge. Parents have photos, texts, the contract, videos. Landlord only has the contract, but his contract is different than my parents'. He's included a section that states they permit him access to the house for his storage needs, and that tenant is responsible for all on-site cleanup and maintenance after accepting the key. The best part was that the date of the signatures on his contract was the date they moved in, not the date my mom flew in and signed. Judge tells the landlord he's a special level of stupid, and then the judge's final remarks were about how disrespectful the landlord was to show up in shorts, a Hawaiian shirt and flip-flops in his courtroom. He never paid a dime, then claimed bankruptcy and started a business under a different name. 2 years later, I went to his house, let out all but 19C from all his tires, and superglued the caps on the valve stems. My family did foster care for a few years, and we fell in love with the last girl we took in, now my younger sister. She was required to keep in regular touch with her emotionally and physically abusive birth mom, the intention being for them to eventually reunite. This woman was a horror. Every single time they interacted, she'd spend the duration painstakingly shredding my sister's self-confidence. My parents worked hard to establish a strong rapport and a supportive environment, and she blossomed under their care. She's one of the most resilient people I know. When the state tried to return her to her mom, she didn't want to go, so my parents sued, I think. Don't really know all the legal details, for guardianship. This seemed like it would be an uphill battle. Here we were, a family of randos trying to steal a kid from her rightful mom. We were really afraid that she would have to go back, and that her shitty family would systematically undo all the hard work she'd done rebuilding her self-esteem. Fortunately, her dumb as mom decided to represent herself at the guardianship hearing. I wasn't in the room, but I heard the audio recording later on, and it's incredible how thoroughly this woman shot herself in the foot. Some highlights. She kept trying to testify while cross-examining people. For instance, would it surprise you to learn that blah blah blah? The judge called her out for this like 6 separate times and she just kept doing it. She would admit to various incidents of emotional abuse, but then try to argue that it was all justified because her daughter was being a bitch. She'd ask witnesses For example, and wouldn't you be angry if your daughter did this? Yes or no? My personal favorite and the best example of her proving our case. It is absolutely not true that I hit my daughter with a wooden spoon. I only tried and missed. I'll prove it. I can show you the mark it left in the door frame. Needless to say, we won guardianship. My sister never has to see that awful woman again, unless she damn well pleases. I'm not a lawyer, but a couple of years ago my family was sued by our neighbors for having a fountain in our front yard because it supposedly made too much noise, causing our neighbors to lose sleep. So my dad, being a nice guy, said, "Okay, I'll try to fix it." We put up walls around the filtration unit and redid the pipes to dampen as much of the water splashing sounds as much as we could. After finishing all of this, my dad even got a noise technician, not sure what they're called, to come around the house with a decibel reader to verify that the noise was virtually gone. The tech walked around a couple of times and told us that the highest reading was 28 dB, so that we were good to go. So a couple of weeks go by no problem, but then we get served with a lawsuit again over the same issue. So my dad is starting to get aggravated over this, and this time decides to get our own lawyer to dispute this. Well, court day comes, and my dad and his lawyer have all the sound readouts, pictures of the stuff we did, etc. Well, the neighbors brought their evidence as well. Their strongest piece of evidence was a recording from inside their house that supposedly showed how loud the filtration unit was, but you couldn't really hear anything except our neighbor lady going, "Do you hear it? Oh, right there. Oh, it's so loud." So when that evidence didn't bear the fruit that they wanted, they decided to show their next piece when ended their case. The next piece of evidence they tried to submit were pictures of our filtration unit, walls, and the various other things we did to dampen the sound. Well, in order to take those pictures, they would have needed to be on our property inside the walls we built. So our lawyer sees this and begins to ask them how they got those pictures, etc. They admit to the court that they trespassed to take those, and thus begins their downfall. Our lawyer showed the judge the decibel report and all that good stuff, leading to our neighbors admitting that the noise actually never bothered them, but it was the sight of our ugly filtration unit. The case was thrown out, and our lawyer then told us if we wanted to countersue we can, so we did. We got them on trespassing and harassment that they provided the evidence for. As it turns out, they were also upset at the fact that the hoa made everyone move boats and trash cans to the backyard. So our neighbors were upset that we got to keep the filtration unit in the front. Like really, TLD, our neighbor said koi fountain made too much noise, took us to court, brought evidence that incriminated him in another crime. Case thrown out. We countersue and win. The fish are happy. You would think it would generally be a battle against equals, professionals v professionals. So my dad owns a small vending machine business. He recently had a problem where a very small account asked him to buy some new equipment for them. He explained to them how it would be pretty expensive for him for not much return, but he'd do it if they agreed to use him exclusively for machines for 5 years. The owner happily agreed. About 3 months later they got some new company in and made him remove the machines. He decides to go to small claims about it. He didn't have a written contract with them and figured the owner would probably just lie about their verbal agreement, but he figured it was worth a shot. Several other people had been in the room, including the manager, when they agreed, so he hoped they'd be hesitant to lie to a judge. The boss shows up with his manager, who apparently used to be a paralegal, so she thinks she's hot sheet. They had to go to some resolution thing where they try to resolve it, and the manager tells my dad how he had a bogus claim. There was no contract. They were gonna sue him for wasting their time etc. Then go before the judge, and she proceeds to tell the judge how they only had a verbal agreement and nothing was in writing, so it wasn't binding. When the judge informed her that verbal agreements were in fact binding, she decided to argue with him. My dad just sat back and smiled while they dug their own grave. Not a lawyer, and I guess not them proving their case but them shooting themselves in the foot, but I took Apple to small claims court over refusing to fix my MacBook. The store leader from the Apple store in question appears for the defense, to which the judge says, "No, you can't do that. You either need to be attorney hired by Apple or Tim Cook himself." The guy says he understands, but just wants to try and rectify the matter by getting the laptop fixed. Judge grants a continuance for us to come back 2 weeks later after Apple's had a chance to fix the laptop. Sure enough, they got it fixed and calmed the whole repair. We show up 2 weeks later for the follow-on hearing and it's a different judge who's booking through the docket like his lunch is getting cold. We come up and the judge's first question to the Apple employee is, "Are you a lawyer?" "No, but this is just a continuation and I believe we resolved the matter." Judge asks why we didn't just file for dismissal if the laptop was fixed, and I said, "Well, Your Honor, I appreciate Apple fixing the laptop, but I gave them ample opportunity to do so without suing them. Now I'm out $60 in court costs because that's apparently what it took to motivate them. I'd like them to cover my costs. I was suing for replacement value of the laptop, $1K plus, so this was a huge bargain for Apple, but this dumb sheet contests it. Says they shouldn't have to pay the court costs because they weren't obligated to fix the computer." The judge, still at breakneck speed, said, "Enough, you'll split it." Judgment in favor of the plaintiff for $30. I'm a huge stickler for principle and wasn't happy with this, and the state code actually explicitly said that as the prevailing party, I was entitled to all my court costs. So I emailed the paralegal at Apple, who had previously emailed me just advising that they were contesting it and would have the store leader appear, said the guy, and told them both, "Look, you owe me $60. Here's a section code. We can save ourselves all a lot of time and you can just remit me $60 and we'll be done. Or, if you only want to send the $30, I will appeal the decision to circuit court and those costs will be $130. They had, as Apple does, been snobby through the entire time, thinking they're above the law. Note, twice they've been told they need a lawyer, and neither time they sent one and said nope, you're only getting $30. So, I appealed to circuit court. I now was spending $130 to recover an additional $30. Circuit court is big boy court, so I'm thinking they have to be hiring an attorney now, which means either they're stupid enough to waste hundreds on this, or they should settle to avoid that. Show up on our hearing date, there's the same faking store leader again. Our case is called. Judge's first question is, "Are you a lawyer?" Apple apparently anticipated this, and this guy had a letter from Apple's general counsel saying, "Yeah, we will allow this guy to argue on our behalf." The judge says that's fantastic that Apple is allowing it, but the court would not. Guy from Apple then goes, "Oh, well then can we request a continuance so that we can determine our next steps?" Judge asks me if I object to the continuance. I say, "Yes, Your Honor, I absolutely do." Apple has been told twice before this by the small claims judges to get a lawyer, and has both times flagrantly ignored the court's request, and seems to think they don't need to listen. Continuance denied, and Apple Bro was ordered to sit down and shut up. I basically go through my recap of the case, and why the code says I'm due the full costs, and now also the costs for the appeal. Apple guy tries to pipe up at some point to contest something I said, and judge had to, now, tell him to shut up, or he will be held in contempt. He was now nothing more than a spectator to the proceedings. Judgment in my favor for everything I asked for now. In my state, after 10 days, I can file for garnishment. I emailed Apple requesting that they FedEx me the amount within those 10 days. At the time, being out this $200 was actually stinging, and they clearly learned nothing about being cocky and said nope, our accounts payable process can take up to 60 days. On day 11, I filed for garnishment against Wells Fargo, their payroll bank. Court approved it and ordered the bank to pipe out the judgment amount plus the $40 for the garnishment fee. TLDR, Apple spent 4 weeks being cocky about paying $30 and it ultimately cost them over $200. A drop in the bucket for them for sure, but still, just bad business. How much labor cost did they waste too by having the store leader keep showing up and paralegal constantly working this? Oh boy, here we go. Obligatory INL. I'm a medic, and sometimes our medical reports get used in courts. Sometimes we have to testify with it, others we don't. Sorry for the length of the stories. Some take backstory to get a full grasp point. This is going to sound morbid, but my favorites are the child abuse cases, because I can write everything the kids tell me in the back of the ambulance / put it in my report, and I don't have to tell the guardian anything. Unless one of those statements include I want to hurt and or kill myself / others. Then I can disclose the fact my patient is suicidal / homicidal to the nurses and staff at the hospital. That's different. My partners usually ask me to do the PD abuse calls, even if they're really simple, simply because I'm a young small female that kids see as a big sister / protective type, and they like opening up to me, because my assessment is more like hanging with your older sibling than a medical questionnaire. Let me give you a few personal examples where the opposing counsel parents have admitted they're performing of child abuse. On the transfer side, I work critical care in 911 mix-up. I have the ability to run both. I'm bringing child X from this facility to Super Special Children's Hospital for treatment for a spiral fracture on their left leg. Child X is about 4/5 years old, and the nurses tell me that it's a potential child abuse case. Spiral FXS are usually a sign of child abuse because of how they get them. Parents are still being allowed to ride with the kid, even though I really don't want them to. I concede and let what I thought the father of the child ride with us. Was on kid's paperwork, kid was on his insurance, etc. The guy creeped me out, but I was in the ass crack of the city, and it was late. Load the kid up in the ambo. They're really sleepy from pain meds, so I quietly dim the lights and leave my work light on by the captain's chair, behind the stretcher, where my monitor is resting with the kid's vitals, hours, heart rhythm, BP. The kid stirs and sees Creep Jude, and pretends to go back to sleep. But I can see the hours monitor keep going at a slightly tachycardic pace, clearly not sleeping. So I begin to ask questions for my medical record, and I don't tell him what he initially told the nurse what happened. I pretended I didn't know. They also didn't know they were under investigation at this point. I had to be on the DL. I also ask him if he could sign for the patient, since the patient was a minor. I'll let the mom do that. I'm just her boyfriend. You're not the biological father? Nah, I've been with the mom for about 2 years now. Okay, he says that child X was falling / rolling off the couch, and he caught their leg to keep them rolling off. A 4/5-year-old would have been just fine rolling off the couch, theoretically. I let go when I heard a pop. Did you grab them by the ankle or thigh? Calf or ankle? I dunno. They slipped. At this point, child X begins to whine. I can't blame them. We were going down some pretty crappy roads. I ask Creep Dude to scoot over so I can make sure the immobilizer is still in place. I used a pen light to see, and I keep the kid covered in blankets. I see a big ass, blotchy handprint on the calf starting to form, but also on the thigh, like someone was twisting it in a big as Indian burn. Except with bone point. I readjust it, cover the kid back up, and ask if me and him can switch places. I put the monitor at the kid's feet so I can still see it, and the kid relaxes and almost immediately falls back asleep. So wait, I'm sorry, I was distracted by child X's vitals. Can you tell me what happened again? Smiling sweetly. Oh yeah, sure baby girl. I grabbed them by the thigh and kept them from rolling off the couch after I told them not to. Were they doing it a lot or roughhousing? They were annoying me, but I didn't want them to get hurt. So you grabbed them by the calf. Yeah, the calf. I put that entire conversation in my report, and when we got to the children's hospital, I told the charge nurse what happened and privately showed her the now obvious handprints. Technically the Creep Dude wasn't wrong. He did grab the kid by both the thigh and calf, but he contradicted himself in conversation because the story wasn't true. And I think that he might have thought he was in the clear, since the bruises hadn't quite formed yet, or he didn't see them. The kicker, the kid came to before I started to leave and thought I was big sister. Ash, not my name. Make sure Dan doesn't hurt you too. Creep Jude went to get mom and other siblings, but I got to watch the shit out of him being violently arrested. Without that convo in the ambulance, they might not have had the evidence. I know it was only my word vs's, but my documentation is a legal document. And I couldn't put mechanism of injury. Asked Guardian. Guardian was vague / inconclusive. Read the following statements from Guardian. So dude got quite a bit of a fallout from it. He got walked past my ambulance on the way out. When we were cleaning up, he was spitting and cursing at me, calling me every name in the book, saying he was going to come find and rap me. Fun times. Another, shorter, story was when I got called out to another DV case, where the mom just blatantly admits she gave her baby heroin to help her sleep. That was a pretty open and shut case. Baby almost slept forever. She didn't tell the cops what she told me, but my documentation along with hospital records got the kid taken away and her put in prison. My favorite, morbid, but I got to help a child, so it makes me feel better about what I heard, was when Granny and Mom were trying to get their stories straight, and I was behind the door without them knowing. I was just waiting on the nurse for patient report before I got in there. Granny, now, we say that he spilled hot water for coffee in his lap, right? When that ambulance driver gets in here? Mom, yeah. They don't need to know about JD, he got enough charges already. Granny, why JD giving him a bad anyway? Mom, I don't know, I was out with Keisha getting my nails and weave. We was gon' go out to the club later, and JD said he'd be watching him for me. Granny, JD told me he wouldn't stop whining and crying, and he was giving him a bag. I pulled the charge nurse in with me and made the SSH motion. She was listening now. 2.G. Why was he crying in the first place? Maybe he was hungry or some. I haven't been home in a few days. I dunno what JD's been feeding him. G. I gave him a bottle while we waited for the ambulance and he sucked it right down. Mama, why is there blood in his diaper? G. I know nothing about that. We hear diaper being undone carefully. Why his booty hole look like it got red sheet on it? At this point, me and the nurse heard enough. Put all of that in my report. She called the cops and CPS. You know what they told me when I walked in? He reached up and spilled hot water. I was macking coffee wit on his legs. No lady. Whoever JD was, burned and sodomized an 8-month-old. You're 8-month-old. It sucked to pretend to be nice to them. I wound up holding and half carrying the baby the whole ride. So many blisters popped, and I don't even want to think of the internal damage. I didn't let them ride with me. I have another few stories like this in my comment history. I love helping to put abusers away, especially when most of my patients are so very helpless. My medical documentation and the fact that patients and their parents, in this case, lie, helps me in the courts put the abusers, opposing counsel away. When I catch them in the lie and it doesn't match the physical evidence and or what I saw on scene, it gets used in court. People will lie all the time. This also happens with police reports. TBH, I don't give a damn what your charges are. Just tell me what you took, because medications can kill you. I'm really sorry this became a longer story. Most of my stories are this way. I just get carried away. I hope it's relevant enough. People really suck. Edit. Words are hard. Edit too. Thank you to whoever gave me gold. And thank you for all of your supporting comments and messages, even the argumentative ones. I don't fancy myself a superhero. I'm just doing what I was called to do, and that's taking care of people. Sometimes it's literally holding someone's guts in, restarting a heart, or simply talking/listening to them and giving them a hug, letting them know that someone does care. Other times it's bringing a life into this world and seeing the stars align in the mother's eyes, and occasionally it's seeing someone join the stars we came from. Much love from me and my nugget due in January. Y'all made me cry happy tears. I was an attorney for the estate of a husband defending against claims for money by the separate estate of a wife over proceeds from the sale of a business back in 1996. Both husband and wife died in 2010. Suit was filed early 2011, went to trial in 2014. Wife got around 10% of the business in 1996. Husband got the rest. He had built and operated it for 35 years prior to marriage and sold it 7 years into the marriage. The whole case hinged on whether the valuation of the business in 1996 was reasonable or not. We say you can't value a business 15 years later with all the documents gone and all the main people in the business dead or missing. They say they have enough info to show the 1996 valuation should have been higher. Opposing counsel gets a big time expert to testify that the business sold for $45 million based on a valuation, but should have sold for $70 million and the husband hid $25 million in real estate in the transaction. We get that testimony and then realize the 1996 valuation of the business was done by the same expert. This is the absolutely most perfect catch-22 I have ever seen. So now we ask, okay, so was your valuation wrong in 1996, or is it wrong now? Expert says his 1996 valuation was right based on the information he had in 1996, but his valuation now is more correct. Which then bears the question, what information do you have now that you didn't have in 1996? Answer, I don't know. I don't have my file from 1996. Nobody keeps documents that long. And despite this lack of records, his valuation is somehow more correct now. Judge basically said the expert was talking out of both sides of his and we won. I did not prosecute this case, but I saw it point the state was prosecuting an individual for reckless conduct with a deadly weapon and criminal threatening with a deadly weapon. It was a bench trial because the defendant was a foreigner and, I guess, the defendant was concerned that a jury would be biased against him. Essentially the state alleged that the defendant waved a gun at 2 employees of a Dairy Queen and then discharged the gun in the air. The defendant was the manager of the Dairy Queen. So at the start of the case, the state requested a continuance because it could not produce the 2 employees. They had been subpoenaed, but didn't show. The judge denied the continuance. So the state decided to go forward. It put on its case, but wasn't able to introduce any testimony that the defendant brandished the gun at the employees, or that he had discharged it near them. There were admissions that he had a gun that night which he had shown to other people and testimony that the gun had been discharged. State rests defense does not move to dismiss and calls the defendant to the stand. I was watching in the gallery with some public defenders because trials were uncommon in that county. We immediately began whispering to each other about how he didn't do the motion to dismiss at halftime. The defendant testifies about how he wanted to scare the 2 employees as a joke. Then on cross, he testifies how he brandished the gun and what angle he was holding it when he fired. Defense rests. The judge had the longest delivery of verdict that I have ever heard. He said something to the effect of, it is rare that you find a defendant that convicts himself by his own testimony. But that is what happened here. Without the testimony regarding the gun and the discharge, there would be insufficient evidence to convict. He goes on and on. While the judge was delivering the verdict, the defendant was standing obviously. He faints and slams his head on the defendant's table. He ultimately was taken out of the courtroom on a stretcher and transported to a local hospital. There was blood all over the floor. The defense attorney, who was in his 60s, looked like he needed medical attention. This would have been instant ineffective assistance of counsel. But he was immediately deported, which is the main reason he went to trial, because he was also a convicted felon, though not charged with felon in possession in this case, and INS was only waiting for the conviction to deport him. So he was sent back to his home country. This was the most messed up thing I have seen in court, and I have seen some wild shit. I felt bad for the attorney, but ultimately contacted lawyers' assistants about him because I saw him do other things that were almost as bad. As a prosecutor, I was worried about his clients, who were paying him for the most part. The court was no longer appointing cases to him, and his ability to effectively represent them. Not opposing counsel, but the plaintiff himself. I was trying a case in DeKalb County, Georgia, against a guy who claimed he had slipped and fallen in a Kroger store late at night while they were waxing the floors. He claimed the only signage anywhere near where he fell was a single yellow caution sign more than 85 feet away. We had a surveillance video and it indeed showed him passing by the sign as he entered the aisle. However, arguably, the sign didn't really indicate what was going on, since it wasn't apparent the aisle was being waxed, and it was quite a distance from where he fell. On the stand, at the end of the first day of trial, I was cross-examining him about the signage, and he made a comment in which he referred to passing the signs plural. It is very unusual to learn a new fact at trial after typically 2 years or so of depositions and discovery. I stopped where I had been going with my questions and asked him about the signs, and he admitted he had taken pictures of them and had them at his house. Well, this is a clear discovery violation, since he's required to turn over all pictures, not just some, and we had clearly asked for them. However, when I went after the guy for concealing evidence, the judge chewed my rear end for getting into a discovery dispute in front of the jury. I still think she was wrong, and I got him to agree that he would produce the images the next day. We adjourned day 1 of trial. The next morning he showed up with the pictures, and it turned out he had walked directly between two caution signs, set up on either side of the aisle like the pillars of Hercules. There was no ambiguity whatsoever about his notice after that, and the jury gave him $0. Former lawyer here. This happens with pretty good frequency, but not at trial, and in a different manner than you are thinking about. In my direct experience, the most common way the state got one of my clients off the hook was via forensic/subpoenaed evidence that takes some time to come back. However, this happens well before the trial point. It goes like this. There is a violent crime and evidence is gathered. 2 eyewitnesses swear they saw my client at the scene. Cops arrest my client based on eyewitness accounts. I meet with client for the first time. He swears he's innocent and was at his girlfriend's house at the time. A few days later, cell records come back and forensics come back and proves that my client was elsewhere, and I get him immediately released. Because I'm sure to be asked. I practiced in New York City in the pre-video cameras everywhere era. Eyewitness accounts were the first and fastest avenue for cops to ID a suspect. It was very common for evil criminal outfits to falsely snitch on each other to get the competition off the streets for a few days, or just to fuck with someone they didn't like. From the cops' perspective, they get put in a bad way if there's, say, a murder and you have 2 to 3 guys who 1. Swear up and down they were right there, and 2. Swear up and down that they saw the suspect commit the crime. The cops aren't really in a position to not arrest the suspect pending further investigation. Not very interesting probably. I work in land law. Had a guy file against us one time for adverse possession of about 20 acres of pretty valuable land. Adverse possession is a legal method to acquire legal title to property of another after some duration of time passes and other factors are met. Open, obvious and hostile possession, etc. Long story short, the guy sued his neighbor, our client, due to a fence being placed in the wrong spot. Both sides assumed it was their property line. Turns out after being surveyed it was not, and actually those 20 of our acres were on the plaintiff's side of the fence, and that fence had been there for a long time. Anyways, in their pleadings and evidence they tried to put on their strongest, most persuasive evidence by saying the plaintiff had been on the property forever and had always used it, worked it, etc. That sounds all good and great, except their lawyer didn't know the law well enough. Which brings me to the one other important fact. The plaintiff was a grantor and neighbor. Basically he sold our guy the land, then sued us years later to try and take it back. How faked is that? Truth be told, the law permits a grantor to adversely possess land previously conveyed, but there's a little sneaky exception to that. If the grantor continued to stay on the land before and after the conveyance, the adverse possession clock never starts ticking unless he takes another act or thing he didn't do. So in all their huffing and puffing, swearing they'd been on the land from time immemorial, they really just killed their own case. It didn't take discovery, a deposition, nothing. They just unintentionally presented their own legally fatal evidence in an attempt to bolster their client's claim to the land. Thereafter all it took was one fairly long letter explaining this, and the case was dismissed after a nominal payment from us, basically buying off their appeal to not waste our time as no ATI fees were in the mix. As I stated above, this probably isn't very interesting to anyone, but it sure gave us a good laugh and a story to tell. Obviously I'm not a lawyer, but this is about 10 years ago now. I was driving on a freeway spur. Traffic had backed up at the end of it. I stopped, and a very large pickup truck behind me did not. My poor car, a special edition Saab 900 SPG that I loved, was utterly totaled. I did not have collision insurance coverage, but no matter, because it was 100% the other guy's fault. His insurance company offered me $750 or something ridiculous, because my car was 1 year too old to be in the regular Kelly Blue Book of Values. They were unwilling to be reasonable, so I filed a claim for $3,000 in small claims court. In my head I felt that was still a bit low, but not a lot, and at the time $3,000 was the maximum I could go for in small claims. Outside of small claims I would have probably needed to hire lawyers and stuff to feel more comfortable about it, and I wanted to avoid that point. Went to court the first time, and my opponent had 2 lawyers. The lead lawyer guy looked almost cartoonishly slimy, as an aside, and an automotive inspector/adjuster for a witness. We waited to go before the judge, but the docket ahead of us ran long, and we got rescheduled for another time the next month. No problem for me. On the new court date, we all showed up again, except the inspector/adjuster witness. He couldn't be there, so he was allowed to testify via telephone. That turned out to be important point now in court before a judge. In response to the judge's questions, after testifying on various little inquiries about how much I had bought my car for originally, any work I'd done to it, etc., I presented a page from the classic car edition of the Kelly Blue Book, which shows valuations for cars that are too old to be in the regular edition. It said my car, if in normal condition for its age, was worth $3,650. It was clear to me that the insurance company had said to themselves, well, the car isn't in the regular Blue Book, so we can just do whatever we want. Sure, let's say it was one step above scrap metal point. At first the opponent lawyer said that no, my car wasn't a classic car, like the kind you'd see in an Independence Day parade, but that's just the name of the Blue Book. Any car of a certain age can be listed in that edition, regardless of whether it's a mint Chevy Bel Air or just an old Datsun, or whatever. The judge recognized that, so the opposing lawyer then argued that my car was in such poor shape that it should not qualify at the normal condition value. Because the opposing witness inspector/adjuster was not physically at the hearing, he was not aware of this change in approach point. At that point, the opposing lawyer called his witness on the telephone and had him offer his expert opinion on the value of my car. Having not been present for the new tactic of arguing that my Saab was a complete rust bucket, the lawyer asked him if the 20-year-old car was in excellent condition. His exact reply was no, it was in average condition for its age. Bam. He'd just proven my case. Oh man, was that satisfying. Point. After a few questions from the judge to button things up, she said, okay, so, ceiling 99, do you have anything else to say for yourself before I find in your favor? Haha. I got the full amount from the Blue Book, so a bit more than I even requested in the court filing. Point. Suck it, State Farm. Not a lawyer, but this happened with my parents. One day in 1993 my sister and I were on our way home from school and daycare with my dad. We were both in the back seat, and like most siblings we were fighting. We pulled off the freeway and my dad turned around in his seat to swat at both of us, then bump. He had hit the car in front of us. We pull over. It was minor, no damage to either car, but the woman driving the other car swore her neck was hurting. The ambulance came out and checked her over, gave her the okay point. Then she starts arguing with the medics. She demands a neck brace. They tell her she doesn't need it. They give her a neck brace. She wants a ride to the hospital. They say no. She demands it. They tell her that they deem it medically unnecessary, and I distinctly remember one of the cops rolling his eyes when she demanded it. Point. Cut to 7 years later. She has burned through 6 lawyers, several doctors. She is suing my parents for $1 million. My parents' insurance company had offered a $500K settlement and they declined. They are certain they can win at trial. Point. It's the end of the first day of trial. The woman is on the stand. It's about 3 p.m. She's talked about the pain and suffering her and her husband have endured because of it. My parents' lawyer walks up to the stand with a photo. He asks her to describe the vehicle that hit her. She testifies she absolutely clear as a bell remembers looking in her rearview mirror at a white pickup truck coming at her and plowing into her at 60 miles per hour. He turns the photo around. Do you recognize this car? She answers, no, I've never seen that car before in my life. Her lawyer panics and asks for a recess for the evening. Point. My dad has never owned a truck. We had a dark blue 1992 Ford Tempo. The jury sent the guard to ask my parents' lawyer if we wanted any money. We asked for the lawyer's fees only. The jury found in our favor and awarded us $200,000, which covered 7 years of lawyer fees for defending against an ambulance chaser at it. She was in another car accident the following month. I'm a patent attorney focusing on patent prosecution. This wasn't my case, but a friend of mine at my firm. To give just a bit of background. In patent prosecution, we draft a patent application, submit it to the USPTO, and have an examiner tell us all the reasons they think it's not patentable. We can then amend, argue, or both, and go back and forth until we get an issued patent or abandon. The examiners primarily rely on prior art, which is references they believe show that our invention isn't an invention because it already exists. So, this friend of mine had submitted an application and gotten rejection from an examiner. The examiner had cited some art that had the very deficiencies we were trying to overcome. There was no evidence of our actual invention in the art at all, but instead, it showed exactly what the problem was with the prior art. The examiner's argument was that our invention would break the internet if it were put in place. My friend went around and around with this examiner, showing him how the art he'd cited was merely evidence of the problem we were trying to solve and didn't show our invention. Finally, he decided to appeal the case. The board fully adopted his reasoning as their decision on appeal, which was his position all along, that the examiner had showed the reason the invention was necessary, not that the invention existed, which in effect proved that the invention didn't exist in the prior art. Ultimately, all that happened was that we got a granted patent out of it. I represented a woman who was on Section 8 and whose landlord was actively trying to evict her without cause. She walked into my office 3 days before her trial was set to take place. Typically, I would never accept a case with such little prep time, but this woman's situation was so pressing and her need for help so great that I just could not turn her away. She was on Section 8 because she had cancer that required extensive and costly treatment and which prevented her from working more than a few hours per week. Her daughter sometimes stayed at her apartment and acted as her caregiver because she was often unable to properly care for herself. For some reason, the landlord decided he had it out of this woman and that he wanted her gone. If she got evicted, she would lose her Section 8 voucher and would be unable to afford both a place to live and her cancer treatment. Stuck between near homelessness, her daughter's apartment was too small for her to stay at, and a slow, painful death is how I saw her. Even if it might have been a slight inner exaggeration. The landlord was mad that my client's daughter sometimes stayed at her apartment to help care for her, as she was not supposed to have overnight guests. In an attempt to evict her, he once called the police on her regarding a noise complaint, while my client was having a barbecue with her daughter and another tenant in the outside common area. He told the officer that they were blaring music, screaming, and disrupting the other tenants. The cops came and found no evidence or indication of any excessive noise, and then left without issue. There was also another tenant in the building who seemed to have it out for my client, always picking fights with her and harassing her. Whether this was at the behest of the landlord, I cannot say. During one instance, the other tenant shoved her to the ground in the laundry area, and they got in a sort of scuffle, and the police were called. Again, the police made no arrests and found no evidence of wrongdoing on behalf of my client. I took her case and immediately called opposing counsel, who said that she would be more than happy to discuss settlement now that my client had counsel or consent to a continuance of the trial. Fast forward 2 days to the morning of trial, and opposing counsel refuses to discuss settlement further and makes a huge scene about a continuance to the judge. Unfortunately, the case was quite old by the time my client contacted me, and the judge agreed that the case needed to proceed that morning. I had no discovery and no hard evidence, only character witnesses to testify regarding the fact that my client was a polite and respectful tenant. Opposing counsel calls the landlord and questions him for a while. All his answers are extremely biased and prejudicial, and we go back and forth with questions and objections for a while. All of a sudden, opposing counsel pulls out 2 police reports, one from the supposed noise complaint and one from the scuffle, and hands me copies, which are marked as exhibits. Usually I would vehemently object to the introduction of these police reports, but I asked the judge for a minute to read them, since I had never seen them before. Opposing counsel, for some reason that I will never understand, had just handed me the pot of gold at the end of the litigious rainbow. The officer's notes on both reports could not have been more damning of the landlord's actions and could not have painted a better picture of my client. They were full of phrases like Ms. X was very polite and we had no issues with her while on the premises. She claims that her landlord has been attempting to wrongfully evict her for some time, and we have responded to other excessive calls from the landlord regarding Ms. X in the past. We find no evidence of wrongdoing on her behalf. The music and conversation were at respectable levels and did not at all rise to the level of a disturbance. Ms. X was provoked by the other tenant, who then repeatedly tried to engage her in a scuffle. Ms. X was very respectful and fully cooperated with the officers. It just went on and on. I'll let the police reports into evidence, and opposing counsel questioned the landlord about them. They were attempting to use the simple existence of the police reports as evidence that my client was an uncontrollable and disrespectful tenant. How could she not be if the cops were called on her multiple times? After some objections, the judge pretty well shut down this line of questioning, and it was my turn for cross. I asked the landlord to refer to the notes section of each report and to read all of the officer's notes on both reports out loud in full. It was one of those glorious movie moments where all the heads in the courtroom perk up, cork to the side, listen intently, and then begin to shake their heads disapprovingly as it becomes clear that the landlord was trying to pull one over on this woman. After a couple of lines of text, the landlord realized what was happening and kept trying to stop reading each time he came to a sentence that praised my client or made a damning statement about his actions in excessively attempting to evict her. Each time I asked him to please continue, and he did so begrudgingly, only to stop a sentence or two later. This continued to the point that eventually the judge took over, scolding him to read the reports in full as requested, or face contempt. Needless to say, we prevailed. The woman's daughter cheered and clapped in the background, and even one or two of the other litigants watching in the courtroom, while waiting for their case to be called, gave a whistle or short whoop. My client got to stay in her apartment and, more importantly, keep her Section 8 voucher. I of course explained to her afterwards that, but for the egregious error by opposing counsel, we might have lost, and next time she needs to take lawsuits more seriously and hire an attorney immediately, needs to find a new apartment ASAP, etc. I have not kept in contact with her, but I'll never forget the pure satisfaction I received from the lawyer that laid the golden egg on her malicious client, promoting both of them to receive the disposition that they deserved. Not opposing counsel, but my own client. I was doing a routine traffic ticket that was involved in a minor accident. My client was charged with being the cause. Since there were no injuries, the case was handled by a magistrate, not really a judge usually. I told him, look, the police office hasn't shown up. The only witness who showed up is a passenger in the other car who wasn't paying attention. I know you claim this wasn't your fault, but we don't need that argument today. All you need to do is shut the fuck up. We go through the basic motions and the other witnesses, like I don't know what happened, I didn't see it. All I know is there was an accident, I know we were rear-ended. Great, case closed. The judge says, well, in light of that, and he cuts her off and says, Your Honor, I have pictures. So to recap, no one could put him at the scene of the accident. No one saw what happened. If you rear-end someone in my state, you are presumed at fault unless you can show they backed into you or cut you off. Which pictures of my clients with the front of his car damaged and their car with the back damaged don't do. The magistrate looks at my client and says, did you hire an attorney for a reason? Yes. And did your attorney give you any instructions about how to act today? He did, without telling me what those instructions were. Did you follow them? No. Okay. Well, in light of this, I'm upholding the ticket. As we were walking out, he asks me, was that my fault? Not a lawyer, and it wasn't a lawyer that proved my case for me, but several years ago, I was at a college football game, 100k plus people partying and drinking in the streets. I was walking along with a buddy, we both had beers, and as we crossed the street, this woman cop told me to pour it out. I didn't understand why, since everyone else was drinking, and I was the only one she called out. Didn't even say anything to my friend, who was also drinking a beer. I crossed the street, took one last swig, and threw the rest away. Probably a half a beer. I continue on my way, Get about half a mile down the street and this male cop comes up to me. He asks my name, then asks if I heard what the cop said to me down the road. I assumed they thought I was underage, and I was about 25 or so pretty blasé about the whole thing. I told him I was of age and answered yay. She said if that's beer in your cup, pour it out. He then asked what I did, and I said I poured it out. No you didn't, you drank it. He said, and he immediately grabs my hand and zip ties me and throws me in this van. I was pissed off and sat in this van for an hour while I watched a parade of people walk by, all with beers in their hand. Anyway, I was given an open container charge, so a month later I have to drive 300 miles to fight this thing. I show up in court and there's this cross-chilled judge presiding over this stuff. There was about 200 college kids packed into the courtroom, and right off the bat I knew I was in trouble. The judge would ask some kid if he was pleading guilty or innocent. The kid would say innocent. The judge would ask what happened. The kid would start with well, I was. And before they could even get out another word the judge would pronounce him guilty, bang his gavel, and move on to the next one. So he finally gets to me, and the judge asks me if I'm guilty or innocent. I told him I wasn't sure. I think that caught the judge's attention, as he asked what that meant. I told him that I did have a beer, but that I'd done nothing wrong. He asks me to relay my story, so I tell him. He asks the arresting officer, the man, if he saw me drink the beer, and the cop says no. I just heard over the radio to look for this guy and I saw him, so I grabbed him. He asks the woman cop why she didn't stop me herself. She said that I had already walked by and was too far into the crowd for her to stop me. So, he was already past you. All you saw was his back. She replied yes, that I was already too far away into the crowd. The judge says there's no way you could be sure he chugged the beer if he was so far away that you couldn't catch up to him. He looks at the ticket and goes, so, this was a game day. Were there other people drinking? And the cops both say yes. He asks how many other people were arrested for open container, and they said none. He asks the courtroom full of other kids if any of them had gotten an open container on that day, and not a person said anything. At that point, the judge tells both cops to step into his office and for me to wait there. I wait around for a few minutes and they all come back. The judge tells me and the whole courtroom that it's obvious they didn't see what they thought they'd seen, that he couldn't believe I'd been singled out. He'd spoken to both officers and he could guarantee it'd never happen again. Then he apologized on behalf of the town, told me he was sorry they'd wasted my day, and told me I was free to leave. It was awesome. Yet another rhino, but told to me by a friend who experienced this while doing her internship at the court. First of all, this is about Austrian law and I try to explain it as good as I can. But when it comes to legal terms my English sucks. Here in Austria, we have a rule in law, which is called culpa in contrahendo, which simply means, when you are about to close a contract you do have some duties that you must not violate, so that even if the contract will not be finished, but you do not obey these duties you are still liable for damages resulting out of this behavior. So here in Austria we have two different types of claims for damages. Ex contracto means from breaching of a contract, and ex delicto means from breaking a law. So if you want to claim damages you must prove that the other person broke a contract or broke a law which resulted in damages for you. So for you to be able to claim ex contracto claims you have to have a contract or prove that the partner broke his culpa in contrahendo, shortened CIC, duties leading to this contract. This for the theory of this case. The case I see here in Austria. A woman enters a shop and slips on the stairs, hurting her ankle. There is no law that you have to permanently remove the ice from the entrance stairs though, so no ex delicto. But the access to the shop, being without danger, is one of the CIC duties of a business owner, and therefore the woman sues the shop for her broken ankle. Please bear in mind that the sums for claimable damages here in Austria are really low compared to the US, and she would have only gotten maybe $1,000, $2,000 signed from it, depending on how long she has been in pain. Civil courts here in Austria have very much interest in solving these cases by getting an agreement among the parties. So the business owner, a clothes shop, offers her, don't know the exact amount, something along $500 in vouchers to settle all this. To this the woman just replies, "What should I do with these? I never buy anything at this shop anyways." And this was the exact moment she lost the case. She just said she never intended to buy anything there, so no possible contract, therefore no culpa in contrahendo for the shop owner. She left the courtroom with nothing but the bills for both lawyers. I'm not a lawyer, but this is a story about my uncle and it's quite brilliant. My uncle has been a lifelong videographer and still works to this day as a news photographer. During the early to late 90s he stopped shooting news and started shooting freelance. This was before everyone and their moms had a camera/editing software/whatnot. Eventually he became a sought after photographer. In the 80s, when he was working as a news photographer, he met and married a reporter/news anchor, of which he would go on to have 2 children with. After leaving the news business to freelance, he decided to start a video editing business with his wife. That went extremely well for a while and they were making money hand over fist. He would be asked to shoot for channels such as Food Network and HGTV, DIY, etc. and then edited into the show. She would work as a middle woman for his clients and as bookkeeper. Eventually she would turn out to be a secret substance abuser and adulterer and their marriage ended in divorce. At this point my uncle was making a couple 100k a year with their business. She decided to sue him for alimony, mostly because he was worth a good chunk of change, but also because she helped him build his business. Her demands were ridiculous, something like 75% of the business for the next so many years or something crazy. My uncle's lawyer was afraid she was going to win because she had played such a big role in building the biz. Fast forward to court day, her lawyer stands in front of the judge and lists off what she wants in the divorce. Once he is finished, it's my uncle's turn. He blindsides her and offers to give her 100% of the business. The judge and both lawyers are confused and ask him if he is sure. Without him shooting and editing there is no business. So basically she would be left with a hell of a lot less than she asking for by asking for X amount of profits. The judge reasoned that his offer was fair and that she could take it or leave it. She was pissed. Her lawyer was pissed, and she ended up getting nothing. Her point TLDR, my uncle started a biz with his wife. She turned into a cheating drug addict. Divorce. She wanted X% of profits from biz in divorce. He offers her the entire business. Total awesome dick move. He is a photog/editor, so she can't do shit with biz because she isn't a photog/editor. She gets nothing. Not a lawyer, but a case I got to witness. I work in it, and a gentleman came to our office asking if we had experience working on / with security camera systems. We do. He was being convicted of assaulting an officer while in prison because the officer said the defendant had too many magazines in his room. The defendant threw the magazines at the officer's feet and walked away. Disrespectful but not assault. The officer then tased and cuffed the defendant and claimed he was kicked by the defendant. This led to a confrontation, but they had conveniently lost the security footage. He wanted me to come in as an expert in the field and explain how that doesn't just happen. I arrived at the court and the man's public attorney raised a bunch of questions about have I ever worked on a prison security system or even on the particular prison security cameras before. I had not, so I was out. But since I was there and the guy seemed nice, I sat in on the trial. During the trial the prosecutor said, "We found the footage, however there seems to be some errors with the files as the visuals are blurry, but you can still hear the audio." When they played the footage, you could hear muffled yelling and someone saying stop resisting. And he just kicked me. Keep in mind this footage was supposed to be 4 to 6 months old. The date stamp on the video evidence. 1 week prior he was found innocent. Not sure if he sued back or anything. Not a lawyer, but I was crashed into about 10 years ago and was given a hire car by an accidents company. Had it for about a month and a half because the insurance of the guy who crashed into me were really incompetent. They kept making things take as long as they could, and then eventually when they sent me the check there was some issue with it which took another 2 weeks to sort. All along the hire car charges were mounting. They eventually came in at a few thousand for a hire car worth not much more. A year or so later they took me to court because of the hire car charges. They said that the hire car charges were crazy, they were to be fair, and that they were 6 times what my totaled car was worth. They were. and that I should have had been given a car worth the same as mine to loan whilst they were sorting it all out. Apparently the law says that the victim shouldn't be in a worse or better state whilst the claim is in progress. I was. Their argument was starting to scare me a little bit as they were asking me stuff like, was it a better car than yours? Was it newer? Was the AC better? On, and all I could do was agree. I wasn't going to lie under oath. The judge stopped them before they had finished questioning me and asked them if they knew a rental car company that had 15-year-old Rovers. Then closed the proceedings and apologized to me that they had wasted more of my time. Not a lawyer, but pretty proud of myself for this. Years ago in my late teens early 20s, I had just gotten my driver's license. I accidentally bumped into a parked car while reversing out of a parking spot. Now I was reversing at a very slow speed, so while I definitely made contact, bumper to bumper, I did not see any damage on either vehicle. But just to be sure, I wrote down my name and mobile number on a piece of paper saying I tapped your bumper while reversing. Did not see any damage, but feel free to call me if anything is wrong for you, and stuck it under the wipers. As I had an appointment, I did this and drove off. A week or so later, I get a call from the local police station about an accident, so I go there and tell them exactly what happened and that I had left my personal information on the other vehicle. The cop says, don't worry about it, there was no bodily harm, etc. Probably let the insurance companies take care of it. Another month passes, I get a call from the police again saying they had a bailiff's letter addressed to me at their office. So I go to pick it up, return home, and upon reading said letter, it stated that I had been summoned to appear in court in regards to this accident. The date at which my hearing was to be held had already passed by a week. So I find out that I had been convicted of paying upwards of €1,600 in damages and had my license suspended for 3 weeks and had to take the driver's license tests again because the accident was considered a hit and run. Apparently some old woman had seen the whole thing, had written down my license plate number, and then had informed the owner upon return to his vehicle of what had happened, and that he had to press charges. The owner of the vehicle was an older gentleman, and while he didn't see any damage, he did go to the cops to report it. So I'm outraged. The cops had waited far too long to inform me, resulting in my absence from the hearing, and I had left my personal information on the vehicle. The vehicle was registered in my father's name, by the by. So my insurance kicks in. My lawyer demanded a receipt, and we got it. A week or two later, I'm in the courthouse. First time ever, with my lawyer, and we wait until my name is called. My name is called, and the judge tells me to step forward. He asks me to explain what happened. I explained them patiently that I did in fact hit the gentleman's car, but at such a low speed no visible damage was done. I had left my name, mobile number, and explanation of what had happened on the gentleman's windshield wipers in case he felt wronged. I had left the scene due to an important appointment and the fact that I didn't see any damage, nor had hit a person or anything. I found it strange that, while they claimed they did not find the note containing my personal information and only had a license plate to go on, all of the letters were sent to me, while if they really only had the car's info, my father would have been the one summoned. The car was registered under my father's name, and I was a designated driver for it. I had visited the gentleman who could not be present during the hearing due to his wife being very ill. He had written a letter stating that indeed he did not find any damage done to the car and did not want to press charges, but felt pressured by the woman surveilling the neighborhood. All of this took 5 minutes to say. When I was finished, the judge smiled and said, "Young man, you should become a lawyer," and proceeded to expunge me of all punishment I had received the last time, with only a warning that if anything similar happens within a year, it will be considered during that trial. I had to pay a €20 fine because I did indeed hit a vehicle, but I was fine with that, rather than paying 80 times that amount due to gross neglect by whatever tart sent me that letter. Yes, it was a 3-day jury trial in family court. We represented the dad. The mom had no reason at all to file for child support. They had literally had a 50/50 custody agreement between themselves since the babies were 9 months old. The social worker recommended they continue joint custody and had much better things to say about the dad. They tried to concoct some kind of sexual allegations, which we kept out, so they really had nothing at trial to go with. What they came up with were these weird allegations that the kids were dangerously asthmatic and the father didn't take it seriously. While it's true that the kids had asthma, they were arguing that they needed special equipment. They produced no medical records or experts, but that was basically their whole argument. The kids were dangerously asthmatic, and the father was neglectful. We rebutted the argument as best we could for an issue that had never come up before. We asked every witness about these asthma issues, and they all said they'd never heard of it before. We also pointed out that the mom's mother, who cared for the kids nearly every day on mom's days, was a smoker. I think we had already won the trial at this point, but what they did next was like the nail in the coffin. They called the grandmother as a rebuttal witness. She was their last witness. They called her to the stand so she could testify that she never smoked inside when the kids were home, and that her smoking wouldn't affect their serious asthma. That was their only purpose for putting her on the stand. As soon as she sat down, she leaned forward and cleared her throat into the microphone. It sounded like this. She had a voice like the evil mom from the Goonies. It was over before she said a word. Jury verdict for us came back after half an hour. But I was sitting on a jury when a genius who decided to defend himself asked the wrong jury selection question. He was a large man who had been cut off on the highway by a not too bright, small teenage girl who had been talking on her cell phone. In his road rage, he followed her to a parking lot, and for reasons I don't understand, the teenager got out of her car to meet him face to face. Predictably, the squabble escalated, and he hit her. This wasn't a slap or a gentle tap, this was full on and closed-fisted. It resulted in several bones and teeth being broken in her face, lots of bruising, and a hospital stay. There were pictures. It was brutal. This brilliant man decided he didn't need a defense lawyer, so when it became time for his side to ask the jury selection questions, he pulled out an organized folder and asked the first question on his well-planned docket, which I'm sure he'd given a lot of careful thought to. Don't you think some women deserve to get hit? The judge literally facepalmed and advised that the defendant take his last gracious chance to lawyer up. The judge also asked that the jury to forget he asked that question. I was dismissed due to similarities in the case with a crime I was the victim of, so I don't know what inevitably led to his guilty verdict. I can take a guess. The entire jury had laughed/gasped/groaned when he'd asked that question, and I was the final alternate released, so I'm sure they weren't entirely able to stricken his question from memory as the judge had requested. Obligatory anal. My divorce took 7 years to complete. It started when my ex moved out in the middle of the night to teach me a lesson, so when my kids woke up the next morning their mom was just gone. I filed at the end of 3 months. When I served the divorce papers to the ex, she accused my brother of molesting my 8-year-old daughter because he told her she should get spanked for some stupid thing she did. I don't remember what. She then took the children on a picnic, but called me at midnight to let me know she had taken them and moved to a neighboring state. I was able to get them back after 6 months solely because she had taken them to another state without notifying the court. She changed lawyers when they refused to do any more work until she paid them. She somehow got the court changed multiple times over the course of this 7-year period. She did a bunch of other things that the court knew about, and a lot more it didn't. The last court she got transferred to, completely on her side's initiative, turned out to be my lawyer's roommate in college. Their wives were roommates at the same college, and they had been friends for decades. They joked with each other and made plans for the weekend at the start of the first appearance in that court, and the ex's attorney didn't request a recusal. Exclamation mark, question mark. Even with all this, when it came to the final decision, the judge was clearly about to rule in favor of full custody for my ex. My lawyer had prepared me and cautioned me not to make a scene of any kind when I lost, because future court appearances regarding my children would be affected. So I was so focused on maintaining composure that I didn't hear what my ex said when the judge says, "What? You did what?" I look over, and her attorney has his head in his hands, and she's standing there telling the judge, when she first accused my brother, she had to go to 3 different judges before she found one who would accept her testimony and issue a restraining order against my brother. Apparently, from the court's point of view, all of my actions were colored by this accusation against my brother and my insistence that my brother had done nothing wrong. The ex's comments at this point completely turned the court's opinion upside down. The judge ruled in my favor, and I got full custody of my children. Not a lawyer, but case that I won. I had worked as a leasing consultant for a very well-known apartment rental company 12 years ago. My schedule start time changed daily/weekly, and it was not uncommon to work 9 days in a row, so it could be exhausting. The office switched to using a fingerprint punching clock when you start your shift, and if you missed it, you had to fill out a time card sheet. So I missed a punch in one morning and filled out a sheet a few days later. I wrote my start time as 8 o'clock, but it was really 9 o'clock. So the assistant manager called me asking about it the day before we put in our time cards for pay, and I said my mistake, it was in fact 9. Let me know if you need me to come into the office and correct it. She said no problem. 2 hours later she calls me again, but sounds strange, and asks why I wrote down 8 o'clock. I said I was confused because the rest of the week had been 8 o'clock, but again no problem if you need me to correct. I was told no, that is fine. Turns out the manager was on the other line who hated me, and they tried to get me to say something that would fire me. I did not, however. I was fired for trying to steal 1 hour of pay. After I got fired I filed for unemployment and actually got it, because when the unemployment office called the manager to get her story, she never returned the call. Jump to me at a new job 2 months later, and I get a court notice that my old boss and company is taking me to unemployment insurance court because they want to dispute the 1 month I collected unemployment. So I go, and they have a corporate lawyer, the hour person, the assistant manager, and manager against me. We sit in front of a judge who hears our case, and I provide my side of the story showing how much the start times change, etc. They provide their side and the judge goes, okay, so the employee was fired for taking 1 extra hour of pay. I interject and say, Your Honor, I never received the pay for that hour. He asks what do I mean. I tell him the problem was caught before the timesheets went in. He rubs his face and says, so why are we even here? My old boss says, because he tried to steal an hour. The judge goes, I heard enough. You will get my judgment via letter. This session is over. He ruled in my favor, so I got to keep that 1 month of pay and the money they wasted on the lawyer, the hour women, and getting people to cover that property while the managers had to go to court probably cost more than the money they were fighting me for. Equals D. Fuck them. Obligatory. Not a lawyer here, but I was being sued and watched my lawyer help themselves lose the case. I caused an accident in 2016. I got bored driving the same route day in and day out, and daydreamed out my car window while going 60 and didn't notice the slowdown in front of me until it was too late to fully stop. I did stop most of the way. They estimate I was going definitely less than 20 miles per hour and possibly under 10 miles per hour when I did hit the lady in front of me. Overall I did more damage to my own vehicle than to hers. We pulled off the road and we checked on each other. Everyone was fine. Exchanged insurance. I had Cartwright insurance at the time with minimal coverage, so I was going to be coming out of pocket on my own damages, and she had bigger brand name insurance, like a real adult. We waited 45 minutes for the cops to come, and then filed the police report, whereupon I got a ticket, which was super cool icing on a sheet cake. I call my insurance company and tell them about the accident. They say they will handle it. I check BBB for their rating, and it suddenly occurs to me that my choice in insurance coverage, while cheap, might end up being really annoying. They appear to have a habit of fighting every single claim point, so I get my car repaired. The lady gets her car repaired. All is well, and then the sheriff shows up at my door with a summons to a panel of judges. I say to myself, good lord, 3 months have gone by. How could this still be a going concern? I see the amount I'm being sued for, a bit over $3K in damages, and I'm just flummoxed. How can my sheet company be contesting that paltry sum? No medical expenses, just fixing the bodywork and the bumper and whatnot. Point. I call my company and they say a lawyer will contact me shortly. They call later and say that if I don't show up I'll have to pay the expenses. And now I know the game. They just want me to flake out and leave me with the bill. So I'm pissed at the stupidity of the situation, but resolved to do everything they ask. Around this time I got new insurance, the same brand as the lady I hit, as it turns out. The date for the panel of judges comes. I have a lawyer. The lady I hit has a lawyer. We go over the basics of the case with the judges, and then they are left to decide whether my company will pay the whole amount or just some of the amount. Apparently the judges ruled in the favor of the injured party. I know this because I get another summons to court for an actual jury trial as my shitty insurance company is appealing the decision. So, it is now a year and 3 months since the actual accident, and I'm in court again, this time with a different lawyer. She was young, very young, working as a lawyer for 8 months young. I don't have much confidence in our case to begin with, what with me hitting the lady and admitting it and causing all the reasonably priced damage. The other insurance company's lawyer comes up and offers a settlement requesting 75% of the original asking amount. My lawyer tries to reach our insurance company's claims adjuster. He is unreachable because he doesn't own a cell phone. The insurance adjuster shows up and is exactly the type of person who you would expect to not have a cell phone in 2017. A short, mustachioed and balding older man with a bad leg, whose demeanor I would describe only as crotchety. He arrived and grumbles, "Well, I'm here, we might as well do this." Gesturing to me he says, "Not like you care." Of course I don't want to be here. I scream internally. We start the trial, all the jurors get selected. It's been hours. It's kinda cool to see the system functioning, but it is boring. We get into the meat of the trial, witnesses. After my very short time on the stand, my lawyer, milliliters, their lawyer, TL, me, milliliters. How hard did you hit Mrs. Lady? Me, not an expert, but I'd guess between 10 to 20 miles per hour difference between our two vehicle speeds. Milliliters, that is all. TL, you caused this accident. Me, I did. TL. What led to the accident? Me, lack of attention. I looked away for a few seconds and didn't track what was happening up ahead. TL. Thank you. That is all. My lawyer then called our side's insurance adjuster and the other lawyer takes him apart. He's clearly not fully up on damage that was done to the vehicle, never actually inspected it. The other side's whole case is based on the fact that our side's estimates of the damage was just that, an estimate, not based on actually removing the bumper and examining the full extent of the damage. Our side kept trying to say that the estimate was enough, but that's just pants on head retarded. Their lawyer then calls their insurance adjuster and they go over the damage and the reports from the garage that worked on the vehicle, and here comes my favorite part. On cross-examination my lawyer asks the enemy insurance adjuster about his experience with my shitty insurance company. He doesn't say much, just that he is familiar with them as an organization. Their lawyer seizes upon that and asks a follow-up question. He inquires about the nature of that relationship. He asks if there is an industry term for my insurance company. My lawyer objects, overruled by the judge. Their lawyer is just looking to expand on my lawyer's previously asked question. Their insurance adjuster, on the record, gets to state that my insurance company is referred to as a substandard and shoddy insurance company. The jury looks kinda shocked. I was grinning. They let me go while the jury was deliberating, but I'm pretty sure they were gonna come back and find entirely against my insurance company. I like to think so, at least. It is delicious to me for them to expend all this effort and then still have to pay everything. They even had a pretty solid offer where they wouldn't have had to pay for everything. What a sheet company. Also, as I was leaving the other side's lawyer thanked me for being honest, which I found confusing. Apparently people make shit up all the time once they get into court. We chuckled together over the substandard comment that got entered into the record. I'm in my last year of law school, so not a lawyer quite yet. However, I've worked with lawyers for several years. The best way to win is when the opposing counsel does not know when to shut up. This past year I did criminal defense appellate work and the office advised not to use the entire time given during an oral argument. Say your piece and sit down. Point presenting at oral argument usually means that you have done a lot of case research and know cases that are either good for you or bad for you. It's especially important to know a case that speaks directly to the issue you are presenting and whether the judges in that case went your way or the opposite way. If it's the opposite way, you better have a good argument to tell the judges why your case is different. Point we had an attorney show us video of a DA's oral argument before our state Supreme Court where he just kept talking. Talked so much that he talked around his issue and the justices kept poking holes in his argument. At one point, a justice asked him about the one case that would have won his case for him. Literally, all the DA needed to do to win was stand up, point to this case, and sit down. But then he admitted that he hadn't even read the case. Our attorney didn't even use his rebuttal time because the DA had already lost the case. The DA later sent out an email to his entire office that he would never do oral arguments again. Long story short, I broke up with my girlfriend shortly after moving into a new house with her, and she went behind my back to have my name removed from the lease before we even moved in and didn't tell me until 4 days after moving in. I moved out as soon as possible and then she was evicted a few months later and left the home a huge mess. We were both sued for back rent and cleaning/repair expenses. I got her to cooperate with me and provide text message correspondences between herself and the landlord where they set up a meeting to remove my name from the lease without my knowledge. We get to court and are called in front of the judge. Neither of us have a lawyer, but the landlord does. When it's my turn to speak, I tell the judge I was never on the lease while I was living in the home and that I can prove it. The landlord's lawyer asks to speak with me privately and I show him the text message transcripts and he said, well, my client is a lying sack of shit. I guess you're off the hook. We go back in front of the judge and the lawyer states that he is dropping the claim against me and the judge asks why and he said something like, in light of new evidence, and I added, I believe your words were my client is a lying sack of shit. The look on both the landlord and her lawyer's face was priceless. I still feel bad for the landlord because my ex did trash that house and not pay a dime in rent for 3 months after I moved out, but she knew getting the money from my ex would be like bleeding a stone, so she lied about removing me from the lease because she knew I made good money. Oh, and if you want more juicy details, my ex's plan was to get me to pay the first/last/ security on the place, about $4,000 worth, move her stuff in for her, then kick me out and have her new boyfriend move in. That didn't work out and she ended up living in a complete shithole for a while after she got evicted, and now she's still unemployed. And a welfare case. I'm not a lawyer, but was on a jury where this more or less happened. It was a DUI case where the defense attorney was very obviously going to go for an extenuating circumstances plea, whatever that is actually called. In the opening statements, the defense attorney essentially said, did he drive while intoxicated? Yes. Should he have been behind the wheel? No. Was he kind of a bad guy? Yes. But you will understand that he had no other choice. However, the judge did not let him use that argument because during testimony, there was never any proof that established that he was in fear for his or his wife's life. The conditions for that kind of defense were never clear, so the judge literally had us as the jury decide, did he drive a motor vehicle while intoxicated, and did he swerve into oncoming traffic while intoxicated? Opening statement from the defense attorney and all testimony made it very clear that he was driving while intoxicated. So he was found guilty, easily. We all sort of went into a room and were like, let's vote. Unanimous on both counts. We were like, do we need to do any kind of due diligence and discuss it? Was an interesting experience, and the attorney was angry, sweating, red-faced, and was berated by the judge several times for acting inappropriately. I was defending a client in a contract litigation. In the first deposition of the case, the opposing counsel was taking the testimony of one of my client's employees. The first exhibit he marked was the contract at issue, a monster, 200-page document with lots of appendices. He hands me and the witness a copy. I start reviewing the exhibit and I immediately notice that it is different from my copy of the contract. It has a lot of handwritten notes throughout. As I continue reviewing, I notice that the notes are from the opposing counsel, including things like "this clause hurts us, but I can still make a case." I stop the current question relating to the introduction of the contract and ask opposing counsel if we can go off the record to discuss the document. He says yes, his client is with him, and I don't want to embarrass him by saying, "Dude, you just handed me a annotated copy of the key legal document." So I say, "Counsel, it appears the copy of the exhibit you've handed me and my client is not a clean copy, but has handwritten notes." He takes a couple of moments and says, "You're right, let me clear this up on the record." At this point, I expect him to say something like, "You are correct, that was my mistake. Let me take those back as inadvertently disclosed and circulate clean copies." The court reporter puts us back on the record, and opposing counsel says, "I've been made aware that this version of the contract has some handwritten notes made by me. I want to be very clear that I'm not waiving attorney-client privilege or attorney work product for any other document. It was all I could do to keep my mouth from dropping open. The entire case, that document was a gold mine, letting me see exactly which provisions he thought were most helpful and most harmful. And yeah, we won the case. Take nothing judgment." Now facts. Had a case against me where a lady's tire blew on the freeway and I hit her. Both went from around 70 to 45 miles per hour. That's where we agreed. A few months pass and I'm informed I'm being sued for medical expenses because my insurance wouldn't cover hers. Case takes 4 or 5 years to hit trial between the whole process and my college point where it went wrong. Lady was from Honduras, living in the States for over 10 years. She didn't want to speak English in court. The interpreter was one of the regulars on the circuit and had been doing it long enough that when my mom came in they knew each other from my mom's days of insurance fraud investigation. I was first to take the stand. I was up for maybe 45 minutes. The jury was largely non-wire, relatively recent immigrants to the US, with the others as white women. Prosecution tried to accuse me of saying things I did not say by showing everyone my deposition and going over it with me line by line before asking again why I lied and didn't tell them that bit. To which I got to end on the satisfactory note of that wasn't what the question in my deposition asked. The lady was on stand for over 4 hours, mostly in cross. The lady gave her deposition in English for ease of my legal team. They gave her up until trial to revise any issues. They provided no corrections in 3 years. In her deposition she stated I was her only accident as a driver. My lawyer found 4 other cases. They had hired a medical expert, the guy who racked up all her costs with steroidal injections, who admitted he might have overcharged her as he didn't know local prices. He also stated he might have recommended treatments she didn't need as he has to rely on what she tells him, and he didn't have a baseline to judge from. So prosecution is on the back foot and decides to try and use evidence that was not admitted to court. My phone records. Judge decided I don't have to prove my innocence, so they weren't necessary. After being told to stop doing that, he decided to nickname me Mr. Sunshine for the rest of the trial and try and make the case as being how I should be accountable for the sins of my generation. To the point he might have called me a school shooter. Jury heads out. There's other lawyers in the room for a separate case, trying to set up a time for their case. As that's done, they talk to my lawyer about how insane prosecuting is. This goes till the jury comes back. I need 3 of 12 jurors to be found in my favor. I got 11. I cannot describe the feeling, if 4 years of a trial, to hear the jury finds the following: on negligence, defendant 0%, plaintiff 100%. My lawyer had just hit 40 years in traffic defense. I'm apparently his only rear-end collision to be found 0% at fault. This was a few years ago when I was a prosecutor. This particular case was a DUI. The defense attorney hired an expert who was a former DUI cop in our jurisdiction. She was a DRE, which stands for Drug Recognition Expert. A DRE may not be what you expect. They don't look at drugs and tell you what they are. Instead, they make observations based on the field sobriety and other tests, and determine what substances, if any, are impairing an individual. They are scary good at telling you the drug category a person used. My strategy was twofold. First, I fought as hard as I could to keep her from being qualified as an expert. If I was successful, great. He now has no expert to undercut my officer. If I was unsuccessful, opposing counsel did a good job of bolstering her opinion. Also good for me, because after his direct where she found very little wrong with the report, and admitted that her opinion was of little value, because she didn't observe the defendant that night. I went over all of the arresting officer's observations. I asked if he was honest. She said yes. So there is no reason to doubt he observed these things? Yes. If you observed X, would you have arresting for DUI? Yes. I asked this for every single observation, and then asked if she would have arrested and testified against the defendant if she saw the same things. Yes. I basically used her to prove he was DUI. I had a rebuttal expert that I didn't even have to call because her testimony was so good for me. I ended up calling him anyway, but just for good measure. Then, in closing, opposing counsel does this rambling story about concentration camps and internment camps and government overreach. At one point he used a racial and the Asian bailiff literally yelped. This is coming so late I'll doubt it'll be seen, but I'll pop in with my 2 cents anyway cause it's relevant. Not a lawyer, but married to a paralegal, so she deals with this quite a bit during the discovery phase. Her firm spends most of its time suing oil and gas companies for things like wrongful death, or polluting someone's land, or my favorite of a gas company deciding to up and leave a property because the owner complained they were leaving heavy equipment on land that wasn't supposed to be used for heavy equipment, then, after leaving, tried to make the landowner pay to have the equipment removed because, since it was on their property and not the property they were leased, it was the landowner's responsibility. The gas company lost that one. It's not quite accidentally proving the case, so it might not count, but generally the firm she works for is suing multiple different companies because they all have some form of liability in it. Every single one will do absolutely everything they can to pin the blame on another one of the companies being sued. This can be anything from allowing people to go to depositions and saying we did everything they said to do, to sometimes having people come into deposition and outright say how the other company ducked up, to many times giving absolute definitive proof that someone else ducked up. One of her earlier cases had 6 companies, with 6 separate insurance agencies all being sued, and every single one of them pulled that because every single one wanted everyone else to be the one blamed for the screw up and not themselves. Some of them provided emails that showed that one of the companies outright ignored safety regulations and worker complaints about lax safety regs. This was super damning. Then the company that ignored safety regs, they provided the other half of the same email chain showing that the company that provided those emails originally were totally fine with the second company ignoring safety regs and complaints. So many of these oil and gas companies will trip over themselves in order to prove that they're not the bad guy in this scenario, that everyone proves that all of them are hugely culpable for it. In some respects it's hilarious to watch, but in most it's just really sad. Seeing up to 5 different companies all knowing that something horrible is bound to happen at a site and all of them washing their hands of it until someone gets killed is infuriating and tragic. I had one at a deposition. I was suing a municipality for false arrest. During the deposition of one of the police officers, I was trying to delve into what I thought was an inconsistency in the officer's story. He claimed he saw my client and immediately approached because he believed my client was about to participate in a drug deal. The problem was that he didn't know whether my client was the buyer or the seller, and searching someone's car was a phenomenal way to scare off a drug dealer. Catching my client with a wad of cash and no drugs wouldn't have been a big win for the municipality's finest. When I asked him why he chose to approach when he did, the officer pointed out that my client was parked illegally and that gave him probable cause to search his car. This isn't really true, but my job isn't to argue with the guy. We went around in circles for a few minutes. I exercised my discretion. As a police officer, I have discretion to approach the vehicle, and so I did. Finally, the cop's attorney got frustrated and yelled, "I think he's made it abundantly clear that there was no basis for his exercise of discretion." I asked counsel, "Are you testifying?" The cop, thinking he was catching on to some brilliant hint, said, "Yeah, there was no basis for my exercise of discretion." Then he gave me a sheet-eating grin, like he's just won the volley. Lawyer here. I have had a lot of cases where opposition can't back up their stupid stories, but actually presenting evidence against themselves is a rare occasion. Unfair dismissal case. Client, big fast food chain, hamburgers etc., for all the right reasons, terminated an employment contract with an employee who didn't show up at work. Employee claimed that she had called the employer saying that she cannot come and she is so sick that she has called an ambulance for herself. Employer didn't hear from her for 5 days after that, and employee claimed she didn't have any credit left on her mobile to call and tell she is sick. Of course employer didn't believe her bullshit, because these excuses are more common than you think. Not notifying an employer about illness is a considerable breach that can justify the termination. Employee argued that she called about the ambulance and she couldn't after that because no call credit, and because of that she had a valid reason missing work and the dismissal was unfair. I said that you never called, you just sent a text message about calling an ambulance while showing employer's phone, and told her that most people are released from her on the same day due to overreacting. Presenting that there was no excuse for her missing work or not calling employer. Asked her about the documents. She of course didn't have anything to present and said family doctor has them. Okay, I asked why the 5-day wait until you called. She gave the same no credit reason and presented the court her phone records to prove that she had called and informed employer after 5 days on her first chance about the illness, thus making the dismissal unfair. Little did the tiny brained girl know that she showed her call history from the day of the ambulance text message to employer to the day her calling in sick and all 5 days between. It showed no call to 911. After the text message, when she supposedly didn't have any credit to call, she had called to half her friends on the same day and every day after that. Also before notifying the employee she had called her friends etc. I didn't even get to argue my why didn't you ask someone else's phone, or why is your profile active on FB or text messages are free thesis that I had prepared, when the judge angrily shouted at the employee, "Why are you wasting court's time here?" Dismissed. Well, that one went well. This will get buried and may not go along with the actual question, but I'll tell the story anyhow. 1980s. I was 18 years old with brand new, 1-month-old, Yamaha Maxim 650 motorcycle. I was in town, going 35 miles per hour and a lady pulls out in front of me. I hit the brakes and lay the bike down, but still hit her front fender and flew over the hood of her car. Ambulance comes and takes me to the hospital. Broken right wrist and broken right ankle. Policeman in emergency room is filling out his report and gives me 2 tickets. 1 ticket for no motorcycle license, driving, and 1 ticket for no insurance. Court date in 4 weeks. Just so happens the court date and my follow-up drive appointment were on the same day. So I go to the drive and we wait and wait. Finally my mom goes to a payphone and calls the courthouse in the other county and lets them know I will be late. Cause drive appointment. Drive checked the rays and says 3 more weeks in a cast on both limbs. So the nurses tear off my casts and put new ones on me, right arm and right leg, from the knee down. So I'm still on crutches. We get to the courthouse and open them big doors, and this place is packed with people, nowhere to sit. I guess they were all there for traffic violations, like me. Mom says wait here, by the rear door. She walks down the side aisle and gets to someone, I don't know who, the clerk. Judge looks at me and says Temet Nos approach the bench. So I hobble/crutch my way up the center aisle. All eyes are on me, my crutches and my 2 casts. Finally make it to the front. Judge says Temet Nos, you have 2 tickets here, 1 for driving without a motorcycle license and 1 for no motorcycle insurance. How do you plead? I say guilty sir. Judge says Temet Nos, I believe you have been punished enough. Case dismissed. I said thank you sir and hobbled miles out to there. Not a lawyer, but a sticking it to them story. Point: a long time ago, 17-year-old me was driving down our small town road to school. After I park my car and get ready to get out, a cop pulls behind me in the school parking lot and turns on his lights. He proceeds to give me a speeding ticket. See, the road I was on passes by a middle school and evidently the school zone lights were on and therefore I was speeding. I knew it was bullshit and the lights weren't on, but I was 17. I wasn't going to argue with the officer. But what I did do was figure out how to get the light schedule for the middle school and went to court to fight the ticket. Point: the officer was there. The judge asked me to step up and explain what happened. I did, and then proceeded to explain that the school zone wasn't in effect and I had the middle school's light schedule as evidence. The judge took that and compared it to the timestamp on the ticket. He agreed that I shouldn't have been ticketed as violating the school zone, but nonetheless I was speeding, but the fine would be standard. I objected and said that if the officer was able to lie about the initial ticket, then it's not a jump to conclusion to assume he would lie that I was speeding as well. I asked for it to be thrown out. The judge laughed and said he didn't agree with my assessment of lying, but threw out my ticket. Not a lawyer, but I represented myself in open court against the DA for a reckless overtaking charge. Point: I passed a car that was going 20 in a 55 miles per hour zone. The oncoming traffic about a half mile down the road was a local police officer. He flipped on his sirens and wrote me up for unsafe overtaking because there was oncoming traffic visible. Point: I researched the exact wording of the law I was cited under. I Google mapped the area, made measurements of the distances involved, filed for discovery to get a copy of the police officer's dashcam which showed the overtake maneuver I performed. Point: the DA went first and questioned the police officer. I was able to cross-examine and ask leading questions that in the end his own testimony proved I never violated the law as written. Point: after I had him give a recount of the events and probed on him to estimate distances, speeds, and times while showing the dashcam video, I then brought out printed copies of the exact law, which gave minimum distances of oncoming traffic for the safe pass. His estimate of distance was probably 5x the distance allowed. We agreed that I didn't speed to make the pass, and on stand he agreed I did not violate the law, just that he felt it was unsafe. Point: the local DA fought me in court and tried to object and use the court rules against me. Judge threw out some of my questions and evidence, but in the end I still got the officer to admit I didn't violate the law he cited me for. Judge ruled in my favor and the case was dismissed with no record or costs to me. The DA outside the room came up to me and said good job and walked away. I'm not a lawyer, but in my recent case the opposing counsel provided documents in discovery that were not known to our side and proved our case for use. Background: I live in a Hoa community in which owners would rent their properties during the high winter season to snowbirds. This one guy became president and didn't like it, so he and a couple other board members went to the community developer who held the rights to all rentals, but had no interest in that, so he did not enforce for many years. The board members traded something to him, which I will not mention as it has no relevance, for the rights to the rentals. The group I was a part of sued a few years later as we knew this went down in a shady manner, and we had other evidence to prove our case. The thing is, the meeting the board members had with the developer was illegal in the sense it violated the governing documents of the community. Only thing was we could not prove the meeting actually even happened. A couple years into trying to get the case into court, and during discovery the opposing counsel gave us documents that included meeting minutes from our own board meetings. One of these meeting minutes detailed the meeting and proved the actions of the board were beyond their powers and illegal. This in the end did them in. I'm not related to mine, but I have researched it because it pertains to my lifestyle sequence of events. There was a gent who was driving with something like 9 pounds of weed in his trunk. He was smoking a joint, going down a main highway. A cop sees him, can clearly see that he is smoking a joint, flashes the cherries, guy throws the joint out, cop smells pot, calls for a drug dog signals positive on the trunk. Open trunk, find the drugs, dude gets arrested in court. The officer who pulled over the guy was testifying. The defense attorney was questioning him. He was giving him the gears about how was he certain that there was pot in the car. What he was trying to figure out was his probable cause to search the vehicle point. So he asked the cop if he could see any drug paraphernalia. The cop said no. The guy presumably had just rolled a joint for the highway and sparked it. The cop then went on his rant about how many search and seizures he has been a part of. He even went to many grow-up busts. He was saying how marijuana has a very distinct odor that was very recognizable, and when he would come home from raids his wife could smell the weed and comment about it. Now that last part is crucial. The quick-witted defense attorney replied with, "So you are saying that your wife could smell marijuana when it wasn't present?" The cop had to reply yes. Probable cause went out the window. Set a precedent in my province. Everything got thrown out. Guy went home. The cop hung himself pontificating about his bona fides, and I love it. Had a case where the plaintiff claimed she signed a home loan promissory note with a different interest rate than the official version we had. The original rate was something like 6.2% for an interest-only period before readjustment, but she alleged that she agreed to a rate of 1.7%, which was absurd for a home loan in the US, and attached an altered version of the note to her claim in an attempt to make the rate a factual issue. When we looked through the entire copy, it was obvious that it was a bad Photoshop of an OCR of the original note, because all of the number 2s had been replaced with a 7, leading to ridiculous results. The loan was originated on March 78, 7005. Payments commence on May 1st, 7005. Even the original loan amount was changed from the $200K range to $700K, meaning she would owe more than double. Her attorney was apparently in the downward spiral of substance abuse, so when we called to inform him of the issue, he said something like, "We'll let the judge decide. Everyone hates banks." The judge did decide in our favor and was glad we didn't try to seek sanctions from the lady or attorney. Bonus fact: attorney was disbarred shortly after this, in part for making up claims and signing things for clients who were unaware of what he was doing. Because we had already won, we let it die without getting to the bottom of whether ours was one of those don't do drugs kids. I'm late to this game, but have a strange version of this. Opposing counsel once brought in a witness during an evidentiary hearing before a magistrate judge to authenticate some documents they were introducing into evidence as proof of payment. Witness proceeds to vociferously state that the documents were not what counsel stated they were and were, in fact, not proof of payment. The documents were introduced as evidence that there was a database of payments that should be made. Our case was predicated on the fact that the payments were never made, and it's actually impossible to prove that someone didn't do something. The next day, magistrate judge tried to refer to them as proof of payment. I politely reminded the judge that the witness the day before had not actually authenticated the documents as such, and had merely showed that it was a list of payments they should have made. This leads to a 1.5 hour recess as the magistrate judge and clerk try to figure out what I'm talking about and go back over the transcript. Presumably, I wasn't in the chambers at the time. Magistrate judge comes back, agrees with me, then says they are proof of payment anyway, because they are the best proof of payment he has, even though a witness had told him that the documents weren't proof of payment. As the hearing continues, because these documents now constitute prima facie proof of payment, we are tasked with providing records that prove that payment did not occur. Again, an impossibility. As you might imagine, this did not go so well. Anyway, we've actually been winning this case overall, funnily enough, but that was an incredibly aggravating lesson in the power of a magistrate judge. But I have a story that somewhat fits this bill. A while back, I was contacted by the FBI of all things. As an aside, that's a shocker. When I got the call, "Hi, I'm Agent Joe Blow," not his real name, from the FBI, I was like, haha, asshole. Go piss off with your friends from Windows Tech Support and the Disabled Veteran Police Llamas Fund. I'll let it go on a bit, and the gist of it was that he wanted to ask me some questions about my urologist. I had no idea what it was about, but I said I didn't speak to Leos over the phone, so if they wanted to interview me, I'd have to do it at their office, so I could see their identification. Otherwise, they could have been anybody, including former police llamas, so that's how I got to go to the FBI office, which they apparently had one of near my hometown. It was just one end of one floor of a regular old office building, which was disappointing. I was expecting something like the opening of Get Smart. Google it on YouTube, youngsters. I'm old. After I signed in on a sadly normal yellow legal pad, they escorted me to an office that had stacks and stacks of medical records jackets. Agent Joe Blow, not his real name, came in and dug around until he found mine. He went through it page by page to confirm that I had all the procedures done that my insurance had been billed for. There was one I wasn't sure of, so he made note of it and got up to go check with someone. He told me not to leave the room because the rest of the office was a secure area and he had to escort me through it. About an hour later, he came back and apologized profusely. Something urgent had come up and the whole office had been involved. He took my statement as something like witnesses unsure whether or not procedure X was performed on date Y. And that was the end of it. Point or so I thought. Point. But when I was later contacted by the defense attorney, he was confused about why I had driven all the way to the FBI office. I explained that I wouldn't want to talk to supposed cops over the phone and such, how I'd signed in, how they showed me my medical records, how I'd been left in the room alone while he went off to whatever the urgent thing had been. And wait, what? Defense quizzed me for about an hour. How many records were there? How were they arranged? Stacks on floor? Stacks on desks? Alphabetized? Yada yada. I recalled the best I could, tried to be accurate. Eventually, he was satisfied and he let me hang up. I got a call about a month later from my urologist. The judge in the case had been furious about the chain of custody issue. Apparently, you're not allowed to leave potential witnesses alone for an hour with the paperwork that's your primary evidence. He hadn't been able to get all charges thrown out, but the majority of them were tossed, and he was able to plead to something trivial that didn't cost him his freedom or his medical license. He got a slap on the wrist fine and had to provide some kind of annual auditing for the next few years. I have no idea if he was really fake billing, but that FBI agent basically screwed up his case simply by leaving me alone with a bunch of medical records. Note, it confused me at first too, so I should explain that the reason the FBI was investigating was because some of the alleged fake bills were to Medicare/Medicaid. At least that's what I was told. TLDR, got a call from the FBI, yikes, and had to go to their local office to be interviewed in an insurance billing fraud case. While there, was left alone for over an hour in a room full of medical record jackets, including mine, which were the primary evidence against the defendant. The defense raised a chain of custody sting that was enough to help the doc beat most of the charges and get off with a slap on the wrist. Not exactly on point, but anyway, I was representing a man who had previously been convicted of soliciting a minor online for sex, basically the exact premise of To Catch a Predator. His sentence was almost up, and the state was trying to argue that he should be classified as a sexually violent predator, which, even though his sentence of his conviction was about to expire, would require him to remain in the custody of the Department of Mental Health until such time as he was no longer deemed a sexually violent predator. He would have been able to petition the court once every year, I think, for a new determination. The AG's office sent out their notice that my guy was going to be evaluated by their forensic psychiatrist. A month or so later, I get notice that the evaluation is complete and they were going to forward it to me as soon as they get it. Fearing the worst, I'm already preparing my motion for the state to advance funds to me to hire my client's own psychiatrist, guaranteed under the statute, when I get an email from the AG. It's their own evaluation, and the psychiatrist found in no uncertain terms that my guy is not an SVP and should be released upon expiration of his sentence. I call the AG, tell him I'm going to file a motion for summary judgment based on the evaluation, or he can just agree to dismiss the whole thing. He tells me, well, our policy is I can't consent to dismissal, but I won't oppose it in court. Okay, whatever. So I file my motion, we have a hearing, where I just introduce the AG's report into evidence, and make a brief argument. The judge asks the AG for their response, and he says he has nothing to add. Case dismissed without a testimonial hearing or trial due to the state's own experts saying my guy's not a sexually violent predator. He got out upon expiration of his sentence and apparently his wife welcomed him back with open arms. IAAL, but this one is a pro se plaintiff, not an opposing lawyer. Client was running a program that was funded with federal dollars and subject to federal regs. As a result, employee violated the regs, so we had to let her go. She filed a pro se complaint of discrimination, checked off every box she could find, race, age, gender, etc. It was pretty clear that she had just checked off all the boxes for the sake of checking off all the boxes after a motion to dismiss. The only claim that survived was for age discrimination. So I took her dep to see what evidence she had of age discrimination. Naturally, I wasn't expecting much point at dep. She testified that the office she worked in ran as an old boys club, that her boss stole her ideas and wouldn't give her credit, that she'd gotten passed over for a promotion in favor of a white male, etc. All fairly standard stuff, except none of it concerning age. She was pretty whipped up about how unfairly she'd been treated, so I asked her, "Do you think being any younger would have made a difference in getting that promotion you wanted?" She slammed her fist down on the table. "Nope," she declared. "Do you think being any younger would have made a difference in getting that raise you didn't get?" Another pound of the first, with a nope. Case over. Final, but I was in court waiting to give testimony in a preliminary hearing for an unrelated case. It was a DUI case. The prosecutor made a point of describing how the weather and road conditions made this case important to proceed with prosecution. Point: according to the arresting officer, it was a dark and stormy night. The car hadn't pulled over far enough for him to approach on the driver's side, which probably pissed him off. So he had to approach from the passenger's side. The defendant only opened the window a small amount. We'd hear later that it was because it was raining so hard, not just to piss off the officer. The officer then claimed he could smell a strong odor of alcohol on the defendant's breath. He asked for the driver to do a field sobriety test, which the driver refused. Again, we'd hear later that it was because it was faking raining out and he didn't want to get soaked, not just to piss off the cop. But the cop got pissed off anyway and arrested him. Breathalyzer came back 0 alcohol. Blood tests came back negative. But cop said he was still agitated and obviously under the influence of some substance. Defendant took the stand, explained why he didn't roll the window down or get out. Judge heard the testimony and said he'd give a proceed/dismissal decision the next day. Point: after my bid was over on the unrelated case, I noticed the defendant's lawyer in the courtroom antechamber. So I walked up to him and said something on the order of, "I was listening to your case. Something made me curious. How was the cop able to smell a strong odor of alcohol on your client's breath all the way over from the passenger's side through a window rolled down just 3 inches on a night where it was so rainy and windy that the arresting officer made a point about it being extra dangerous to be driving under the influence?" The lawyer thought about it for a minute, then smiled and thanked me. The last I saw of them as I was leaving was him going back into the courtroom and leaning over to talk to the clerk, presumably to get the judge's attention. Point: TLDR was in court to testify on a case. Saw another dude's DUI preliminary hearing. Cop lied on the stand. Prosecutor asked him exactly the questions required to prove cop was lying. Final point: but my friend once bought a truck off Craigslist. Normal transaction, couple $1,000, nothing else added on. He said the guy was kind of a redneck but all went fine. Point: when my friend tried to register the car in his name, the DMV says they won't let him until the lien on the car is paid off. Turns out the guy had taken $10,000 out as a loan using his car as collateral, but didn't tell my friend that when he bought it, effectively transferring that debt to him. Sorry if this is incorrect, I know, but maybe someone smarter can explain the concept of a lien. My friend sues him saying he sold the truck under false pretenses and transferred this debt without his knowledge. Point: my friend was really nervous before the case because it was basically his word against his. The guy could just lie and say he told them about the lien and the case could be dismissed. Point: well, something way out of left field happens. The previous owner shows up to court and instead of claiming he told them about the lien, he claims there was no lien. His argument is that there was no lien on the truck and my friend took the loan out and then sued to try to get his money back for the truck. Well, of course there's a gigantic paper trail of documents proving the lien in question with this guy's name all over it. Judge quickly awarded my friend the case. Don't know if that guy got in trouble for perjury, but he sure as hell lost some money. Edit. Lien not lien. Prosecutor here. Brief background. New York has one of the most liberal post-conviction relief statutes. In addition to his direct appeal, a defendant can challenge his conviction an unlimited amount of times, regardless of how long it's been, since his conviction. In 2010, the United States Supreme Court held, in Padilla v. Kentucky, that a defense counsel is obligated to inform a non-citizen defendant that pleading guilty may result in deportation. Prior to this case, defense attorneys had no such obligation. A defense attorney could not, however, misadvise a client that pleading guilty would not result in deportation when it, in fact, will. A subsequent Scottish case, Chades v. United States, held that the Padilla rule is not retroactive. It does not apply to those convictions that were final before 2010. So for those convictions that were final before 2010, defendants will argue that they were misadvised rather than receiving no advice. Anyway, a defendant who was convicted in 1997 filed such a post-conviction motion through an attorney, alleging that his attorney told him he would not be deported. The court granted an evidentiary hearing. On cross-examination, I asked him, so your attorney told you that you would be deported if you pled guilty? Defendant, no. Me, he didn't. Defendant, no. Me, did he tell you anything about immigration? Defendant, no. No further questions. Motion denied. Looking back, this was more sad than anything, I guess. Also not a lawyer. When I was young I testified in court at a restraining order hearing against a relative. I won't go into tons of detail, but among other issues he was very mentally/emotionally manipulative toward me and other children in my family, to the point that we legitimately feared for our safety. Threatening to kill pets, etc. I went up to the stand, gave my short testimony of how he treated us, and ended with begging the judge to keep him from hurting us anymore. Not super dignified I guess, but I was just a kid, never been in court, and was terrified out of my wits. Then it was the relative's turn to defend himself/cross-examine me. He was representing himself. Brilliant, right? Instead of denying any of the seriously horrific things I'd claimed he had done, the guy spent the whole minute that the judge was too open-mouthed with shock to do anything, making thinly veiled threats, which he, very pathetically, tried to disguise as legitimate examination questions. The most outrageous was asking whether or not I felt a clear conscience about standing before God on Judgment Day after telling such lies about an innocent man. Looking back, the threat of going to Judgment Day could definitely be taken as a death threat. Oof. The judge told him to shut up, looked at my pale confused face, and said, "You don't have to answer that." Then he absolutely raked the guy over the coals about how someone could treat a child like that, told me I was a brave kid, and that he believed everything I'd said, and ended the trial in our favor 100%. Most relieved day of my life. Lol, I know, but I just dealt with this at the court hearing against my ex for a domestic violence order of protection. I was given free legal representation, since I'm the victim, and my ex's mommy and daddy bought a nice criminal lawyer to handle his felony charges. When they saw I was taking him to court over the restraining order, they figured they'd let the criminal lawyer represent him during that too. That was a mistake. He was in a very rigid, criminal law state of mind. He was very accusatory of me and trying to defend my ex's violent actions by claiming I was being aggressive. In a civil case, that was the wrong move. He was basically giving the judge every reason to give me the restraining order. Spoiler, she awarded me a 3-year order. His biggest fuck up was letting Jason speak up in the hearing. With his other pending felonies, most people are told to remain silent and that it's the best option for them. Jason was stupid, and he spoke up anyway. His own lawyer was questioning him. Throughout the process, the lawyer kept brushing off my testimony as allegations. The biggest thing he brushed off was that Jason strangled me that night. It was just Jason and I at his house, so there were no witnesses. If Jason stayed silent, He would have been fine point, but he had to speak. His lawyer was like, so you didn't try to choke Breha? You weren't trying to do that? No, sir, I was just pushing her away from me. And why were you pushing her away? Well, I didn't want her near me. I pushed her away, and my hand happened to be wrapped around her throat. There was a brief pause in the courtroom while his lawyer scrambled to get to his next line of questions to recover. After the hearing, I got my hands on the transcript as soon as possible and gave them to the prosecutor. His arraignment is this Friday. If you don't want felony charges, maybe don't do things that qualify as felonies. Edit. Also, how in the faking world do you push someone and then oops, squeezed her throat? That's not how you faking push people. It still boggles my mind. It was a Dewey blood case. The police had obtained a warrant to get the blood because my client had declined to give consent. During the 104 hearing, probable cause hearing, the prosecutor, in an effort to make it clear my client was being a belligerent drunk in the air, asked the cop, was the defendant cooperative in the air? The cop replied, oh no. He was terrible. In fact, we had to sit on him to get the blood. This might not seem like a big deal, and it certainly didn't seem like a big deal to everyone who wasn't a lawyer or a judge in the courtroom, but it was like a grenade went off. I maintained composure. The prosecutor abruptly ended his direct. It was my turn to cross. I asked a bunch of superfluous questions and seemed to wrap it up without a big deal, and then, like Columbo, turned around. Q. Oh, just one more thing, officer. You had mentioned that you had to sit on Dave to get the blood. Yes, Q. When you say we, who do you mean? Well, me and Sergeant Friday and 2 orderlies and 2 hospital security guards. Q. Did you get the blood then? A. No, Q. Well, how did you get it then? A. Well, the defendant was being so belligerent we had to strap him down, and even then he was so combative they had to give him a shot of something that made him go to sleep. Then we got the blood. The next cop gets on the stand. I ask him if Sergeant Friday's account was about right. He confirms it. None of this was in any of the reports. I was trying the case on an entirely different theory. After testimony, I rose to deliver my argument, which began in true erudite fashion with, Your Honor, today I learned that one question blew up in the prosecutor's face. He should have known that fact, even though I wasn't privy to it. The rule of law is that you need a warrant to get blood under McNally, but you cannot go to heroic efforts to force someone to submit to the phlebotomy. SP. Cases are evaluated in the totality of the circumstances. This wasn't even close. The prosecutor moved to dismiss after a week of trying to put sheet back in the horse. Not a lawyer, but was taken to court myself, in Orse. Basically, story goes, I was driving in wet conditions, and this hill near my house on a major intersection is extremely slippery when wet. I attempted to turn right up a hill, and became stuck blocking half of the oncoming lane. To give further backup, I had been sitting there waiting for an opportunity to go. No cars were coming down the hill, nor did I see any once I had pulled out. A lady came down on a scooter and flipped it. Police were called. I was told I was not at fault. I was also not charged with anything and let go. Basically end up in court. She's claiming I didn't give way to her, which then caused the accident. I represented myself and provided information that my wheels had been changed 3 months earlier with new all-weather tires, and stated that the woman knew full well I was in the path and proceeded, and due to her obvious inexperience in riding, and due to her attire, she failed to slow down as any reasonable person would, resulting in her sending herself to hospital. Because it was small claims, I had like 4/5 people that were hearing my case essentially acting as judges. The lead guy turns to her and states, "Did you see the car in the road as you came over the hill, which was 200 feet / 100-150 m away?" She replied yes, that she expected me to move. They deliberated, stated that she admitted to seeing me well ahead of time, didn't slow, didn't take any precautions, and was the cause of her own accident. She was after me for over $6,000, and I got to walk out of court smiling. I had to miss my grandmother's funeral for the trial, so as far as I'm concerned it was sweet justice. Props to the guard that was at the court, gave me a pep talk beforehand, and high five apostrophe me once I won. TLDR, Woman had an accident, sued me as the cause, admitted in court to basically causing her own accident. I got to walk out smiling. IAAL point: our client, defendant, makes a toy that the plaintiff claims infringes plaintiff's patent. They sue for patent infringement and ask the court to grant a preliminary injunction preventing the toy from being sold between now and Christmas. Now, to get a preliminary injunction, you have to show that if the defendant is allowed to act freely while the case is ongoing, you will suffer irreparable harm, that there is no way you can be compensated with money or anything else later. This might apply if your business is literally going to go out of business, or if that logging company is planning to cut down the 2,000-year-old redwood, but it's a hard thing to prove for ordinary lawsuits. The judge asks plaintiff's counsel, now, let's say I don't grant the injunction. Defendant sells toys all year. You win the patent infringement case. I order a retroactive license with a 5% royalty. You only make a 4% profit on each toy. Wouldn't getting more money per sale than you would make if you had a monopoly repair the harm you suffer from competition this Christmas? The counsel says, no, Your Honor. Because you can't order a license above 1% royalty, which is the industry standard in this field. Judge, I can't. You can't. The case citation is someone v. someone, even if the defendants sign a consent decree and everyone's happy with a value higher than 1%, you can't. The judge ended up denying the injunction for a different reason: lack of likelihood of success in the actual trial. That trial hasn't happened yet, but if plaintiff somehow wins, when it comes time to determine the retroactive royalty, they are going to be kicking themselves for going on the record and telling the judge he can't give them money. Not a lawyer, but I had to take a lady to small claims once. We had a minor car accident. She hit me in a parking lot. Nothing serious, but her insurance refused to pay, so I had to pay my deductible, and she refused to give a statement to my insurance company. Long story short, before court I still didn't know what her side of the story was, since she never gave my insurance a statement, but I did know that she was 100% at fault. So I take her to court, and before we see the judge we have to share our evidence with the other party. So the only evidence she brought against me was her statement to her insurance company. Lo and behold, as I'm reading her statement for the first time, moments before going before the judge, I find out she lied about how the accident happened and said she was in a left turn lane. I swerved around her, yada yada yada. There was no left turn lane. Her story was a complete made up lie. So I told the judge what really happened, explained how I'm suing for my deductible because she lied to her insurance company, and gave him her evidence of a statement and some Google Maps images of the location where the accident happened. When it was her turn to speak, she just said to the judge, you already have my evidence. I don't have anything else, and started crying. She also tried to call me a stalker because I had a printout of her public FB page with her posting the day of the accident a picture of her car with the status all my fault. She was nuts. I got every penny back. Right now I'm going through a messy divorce. Back in February there was a domestic incident. I usually never report this stuff to the police because my daughter and I's survival was tied to his ability to hold a job, so only screwing my daughter if he got arrested/went to jail. Plus the 1 or 2 times I had called in the past, the police were no help. However, I was no longer tied to him financially, so I went to the police the next day, showed them the bruises, told them what happened, and filed a report. I've learned it does no good to report to the police unless you have actual bruises, broken skin/blood, or third-party witness. Red marks from being choked are not enough because it devolves into a he said she said that is understandably impossible for the officer to discern what really happened. Fast forward to the protection order hearing, and his dad's defense divorce lawyer was having a fit. She was insisting that I was making it up to gain an advantage in the divorce. They had me take off my sweater to show my bruised arms. They, opposing counsel/husband, claimed I made those bruises myself. Lol, never mind that. I don't know how you could even make bruises where they were with the pattern of his hands. On cross-examination she was hammering away on me, trying to poke holes in my testimony. However, she was thinking like divorce lawyer and not a criminal defense attorney because she was asking me questions about the marriage, not the incident in question. I think she was trying to paint me as unstable because we came to this question. Lawyer, isn't it true you have been sleeping in your car for many nights? Me, yes. Because I have been trying to avoid this exact type of violence. The question pretty much backfired on her because if there had been any doubts in the court's eyes, she pretty much established that there was a pattern of behavior where I feared for my safety. Point protection order issued. Lawyer here. I had one civil case where opposing counsel essentially proved my entire case for me, although it happened during depositions rather than at trial. It was an unusual case, so I can't provide much in the way of factual background for confidentiality reasons. But opposing counsel was a very thorough, very diligent, probably very booksmart, and certainly very green attorney. She decided to impress everybody by learning every detail contained in every document involved in the case. Unfortunately for her client, she forgot that my case hinged on her client having negligently advised my client about information contained in one of those documents. That is to say, her client misinformed my client about the contents of one of the documents in such a way that caused some problems. So, when deposing opposing counsel's client, I did what I generally do at depositions. I stayed pretty non-confrontational and stuck to the what did you know, when did you know it, who did you talk to, when did you talk to them, walk us through the timeline of events. Are you familiar with these documents? What do you think these documents say, and is that consistent with what you told my client? Really open-ended questions with plenty of opportunity for the witness to put her foot in her mouth. And she gave me the answers I wanted, particularly that her understanding of a particular document was not correct. Did she share that understanding with my client? Yes. I wrapped up my questioning and looked forward to seeing how opposing counsel would try to spin her client's testimony at summary judgment or at trial. Then opposing counsel opened her mouth and she pointed to the exact line of the exact document that formed the crux of my case and asked her client what her understanding of that line was. Her client repeated her mistaken understanding, which she had shared with my client, causing all of the problems. Then opposing counsel asked her client to read that line out loud, then asked if she still had the same understanding of that line. Of course, now the answer was no. And then she asked her client what the line actually meant, and her client now had the correct understanding. Opposing counsel seemed satisfied with her performance. She had successfully impeached somebody. I was thrilled. A couple of weeks later, we went to mediation. I provided the mediator with some excerpts from the deposition transcripts and highlighted opposing counsel's helpful contribution. Opposing counsel seemed confused as to why the mediator laughed at her when she said she thought I didn't have a case. Then the mediator explained to her exactly how she had made my case for me. Her attitude changed and we wound up with a pretty favorable settlement. One time, we were deposing a company who cleaned grates for a particular car company, and after cleaning the grates would allegedly not properly place them back where they went, and people were falling through the grates and getting hurt, some 15 feet in a reservoir. We were deposing one guy who worked for the corporate office and was clearly prepped by counsel. He was extraordinarily evasive. My boss being the man that he was made several attempts in order to trick him, but it was a no-go. He just stuck to whatever his attorney told him to say. There were several problems with the case, starting with fact they were the only ones who dealt with this particular grate, and we've narrowed it down to this particular company being the party who handled the grates. The deposition itself took roughly 2.5 hours with this one guy. We were asking such questions that were so specific that they were borderline pedantic. But this guy was hard to crack, so to speak. Found out they have been sued many times and he was used to it. I asked a question about supervision and he stated the typical, I train everyone according to perform the function of their job. After that I asked, do you watch every employee you train carry out the functions of their job? He said, sure, in a smug manner. Then I asked, do you make sure they do it right? For this he pulled back and said, they always do what I tell them. That's basically what he said for the next 20 minutes before we concluded. The kicker was we were deposing somebody who worked for him, and the actual next and the boss just left. I don't know what got into this guy, but he was just an open book. Any question that was asked was answered the way we wanted it. For instance, the question asked was, did you put the grates back according to how they were arranged when you got there? His reply would be, no, and would add, it was common to cut corners in order to get out of there. We were trying to figure out why in the hell this guy was so forthcoming. Did he not care about losing his job, or was he quitting? My fear was to find out if he was quitting and got another job at another company, which might cause some bias later on, but no, he was just naive. They spent all the money on attorneys prepping the other guy and didn't even make any effort whatsoever to have this guy speak to an attorney to figure out what to say. It was mind-boggling, and he informed us that his co-workers would say the same thing. It doesn't get any cleaner than that. Compared to the other, when this deposition only took about an hour to sink the other side. Not a lawyer, but I had to go to court for an accident and the guy hired a lawyer for it to come down to this. He had pulled out in front on me in a passing zone from a bar as I was legally passing the car in front of me, and I T-boned him. He was under the influence, but we didn't have a warrant to test his blood. This is important, it comes up later. At the time, so he just got a ticket for the accident and decided to fight it. We get to court and we get called up. It's me and my buddy on one side, the guy and his lawyer on the other side, and a third party bystander who helped pull my friend and I out of the car because we were stuck on my door anyways. The guy starts arguing that he did nothing wrong and isn't at fault for pulling from a driveway and hitting me. His lawyer then reads out the law to try to prove the judge wrong, and reads, a person who is entering a major highway from a private drive do not have the right of way and are only permitted to enter the highway when it is safe enough and there is enough time. And the judge cut him off there and said, well, apparently he didn't have enough time since the defendant collided with your client. So anyways, the judge dismisses that charge, but the guy isn't done and wants to get the points off his license because in the past his license was suspended and doesn't want to get points on his license. He says, in the past 5 years I haven't had a single infraction. The judge then reads off his prior tickets from 1995 to 2008. He had 3 DUI charges, 1 failure to take a breathalyzer, and 3 speeding tickets, 2 of which were 30 over. The other was 25 over in a school zone. The judge laughed and said, I'm going to give you the points and the fine. Case closed. Throwaway account because paranoid and dark-sexing. IAL point. My first ever trial dealt with a commercial lease on a restaurant. The tenants literally ripped out fixtures as they left, selling off toilets and sinks to make a quick buck, despite those being there when they moved, not having paid rent in months, and otherwise having been coddled for months. Trial had been adjourned twice by opposing counsel. The third time, he sent a student in his stead. Not an articling student, like a resident in medicine, already graduated law school, a kid who just finished 1L at the local university. I remember after first year of law school that I didn't know sheet from Shinola. Whether I know that much more now is a matter of debate. Point. It was a mom and pop restaurant, and hubby was trying to argue that he had no liability because his wife hired him on as an employee. I get up and began asking hubby on the stand about a contract that he signed on behalf of the company. Objection. The kid proclaims, we don't even know what contract he's talking about. The judge looks very unimpressed. How many contracts are there? He asked. Point. At this point, the hubby volunteers on the stand that he signed as guarantor on all the loans for the business, signed a contract with the general contractors, and settled a mechanics lien on the property by the same contractor, all in his capacity as line cook. It was the best cross-examination I ever did, and I barely said a word. We won at trial. I'm not a lawyer, but I had an experience that seems to fit this situation. Point. I was driving home one evening after work and had just pulled into the parking lot of my apartment complex. This lot is basically a road with parking spots on either side of the one-way road, not parallel parking spots. They're perpendicular to the road. This jacked up truck in front of me had gone through the entry gate, and then I went through the gate. But the truck stops in front of me after I got through the gate. Then he starts to go in reverse to back into one of these spots, only I'm right behind him. I can't go anywhere because the gate has closed behind me. So I start honking the horn to get him to stop. Either he doesn't hear me, unlikely, or he ignores me, but he keeps going until the bottom of his bumper has scrapped along the top of my hood point. Then this woman runs out of one of the nearby apartments, yelling, "I saw the whole thing. It's your fault." Yelling at me. I was pretty perplexed, seeing as I was stopped, and he was in reverse. But then I found out it was his girlfriend. The two of them were total assholes, yelling at me and saying they were calling the cops. I wanted the cops because I knew I wasn't at fault, and I wanted their documentation for the insurance. Waited like 30 minutes, no cops. But then I decide to call the cops myself. They'd never done it, and minutes later a tow truck drives by. He'd heard my call on the scanner, so clearly they'd lied about calling the cops. Finally the cops show up. They talk to me first, and I explain what happened, briefly in a couple minutes. Then the cops go over to the other guy, and spend like 20 minutes with him talking to them. I can't hear what either side is saying, but the guy is aggravated. Finally the cops come back, and tell me he admitted he was backing up, which makes it his fault, and when they explained that to him, he kept trying to justify why it wasn't his fault. But they weren't having any of it. I get a copy of their report. His insurance pays for the repairs. Justice/karma is served. I'm not a lawyer, but I feel this is the thread for this story. I'd like to announce that I was around 19 when this occurred. Very immature and petty to boot. So I lived with my so's parents at the time. It was a 5-acre block in a rural area. We had next door neighbors a few paddocks away, and my partner's family made friends with them. I spoke with them occasionally. I'd call them an acquaintance to me personally. As does happen sometimes. Bad neighbors fight, and it was a glorious display of immature pissing contests. A lot of things happened with these neighbors, but this one is the thing that made it to a courtroom. They had horses, and one day after a few shenanigans they started piling up their manure on the edge of the fence in the perfect position to have the wind blow straight through it and into the kitchen sliding door of our house. We ignored it as best we could. One night they got drunk, and one of them did burnouts in their paddock, really close to that fence line, causing the manure to spray all over our property into an area where the kids ride their bikes. We had to clean it up. So we did. I then suggested we put the bags of horse manure at the front of the property and advertise them for sale at $1 per bag. Bargain. Just for sheets and giggles, to show in a smarter's way that we were entertained by their antics. Then I got served with an intervention order. And I swear to holy Jesus it said in the part where she filled out the reason why was that I stole her horse manure and a few other things. Like that it stood at the fence line and called her names. TBF, I had called her names, just not at the fence line. It was to her face. She never showed up to court to have it approved. I stood there while the judge read her reason, chuckled, saw that she wasn't there, giggled and told me it was dismissed and to stay out of trouble. TLDR, a neighbor tried to put an intervention order on me for stealing her horse manure. Not a lawyer, but recently went to court for a case of theft and check fraud earlier this year. An ex-girlfriend of mine that I hadn't spoken to in 6 years called me up and accused me of taking her checkbook and paying for tickets through the MVA. I had no clue what she was talking about, but she was adamant about me going into her apartment, looking for a secured box, opened it up, taking her checkbook, and paying for 3 speeding tickets in my name. I knew it was all bullshit, but for extra insurance I hired a lawyer. I explained to her everything. We broke up, we both moved on, had no contact with her whatsoever until this accusation. She even mentioned in her report that I blocked her on Facebook and her phone number in my phone. To her, that was enough proof for me to be guilty, not the constant calls of harassment, text messages, Facebook messages, and voicemails she left. I had a copy of my complete driving record dating back to 2005. I hadn't had a speeding ticket since 2008. And all this information that my ex had was from the personnel who she spoke to at the MVA. My lawyer went through her bank records. There were no transactions to the MVA in over a 6-month time frame. I had no speeding tickets. Yet she still, even in the courtroom, swore up and down that I stole from her and paid something I never had. The state's attorney even had the gall to ask me if I would pay restitution. My lawyer and I laughed in their faces. Needless to say, the charges were dropped. Arnold, but this is what happened to me a few years ago. One late evening, a few days after a night party, I went to pick up my car, and whilst driving home I turned left onto another road and barely managed to avoid a car driving from the other direction with all lights off. This was in a place with no street lights. Turns out it was an unmarked police vehicle with hidden emergency lights, which they turned on behind me, so I pulled over. As I was sitting there trying to make sense of what happened, I figured they must have been on a stakeout or a sneaky pursuit or something, and I must have ruined it for them. Felt sorry for the guys for a second. Nope. The driver cop came all angry by my window and tried to play it off as I had done something super bad, and there was no chance that I could have missed them since they had every light on etc. Turns out they were fishing for tickets, a thing cops in my Eastern European country do when the quota hasn't been filled and they get nudges from their superiors. His colleague was sitting in the car the whole time while the angry dude tried to get every passerby to sign whatever he had written down for a good 20 minutes. Everyone refused and stayed around to comfort me as this guy was full blown shouting and trying to get me to crack down and sign that I was in the wrong. I didn't sign, but I gave up my driver license and took them to court. My good friend who's a lawyer took me as a client and told me they found a witness, so they are gonna go to hearings and soon I'll have to testify myself. After the first witness hearing, she called me to say I'm getting my driver license back. There's no need for me to testify anything anymore. The case is closed. Here's why. The first witness they brought in was a taxi driver. When the judge asked him what happened, the guy said something like, "I have no idea, Your Honor. They often come up to us in the taxi parking and threatened us to sign whatever they bring, or else they remove our taxi license from us." Judge facepalmed and closed it there. And then after a while I found out that zealous cop guy had to write a shit ton of papers and go on suspension without pay for a few months. Not gonna lie, that felt good. Obligatory, not a lawyer, but lived in an apartment many years ago above a council flat provided by local government to those who are at risk, which was occupied by a drug user. It was an old building with squeaky floorboards, and when he was using, our downstairs neighbor started getting paranoid delusions that we were prying up the floorboards to spy on him. This would make him violent, and he would stand outside our door yelling threats and obscenities at me and my two housemates on a regular basis. We tried for ages to get him removed from the apartment for fear of our own safety, but it wasn't all that easy to arrange with the council. Eventually, after months of pestering them, we got a court date to have our case heard. My two housemates and I were there on one side, the neighbor on the other. At one point the neighbor starts volunteering testimony that, yes, he had been standing in our flat holding a knife and threatening us, but that the whole event was being taken out of context. My flatmates and I all looked at each other in puzzlement, but somehow managed to shrug and wink and convey to one another, "Let's see how this plays out." In the end the judge decided that the guy was a threat to us and himself and needed to move out of the apartment, and specifically cited the incident of him standing in our property with a weapon. An incident which we verified with each other after we'd left the building never happened. None of us had ever been so dumb as to actually open the door to the guy, and he had fabricated the whole story while trying to defend himself by explaining the context of his actions. Obviously late to the thread here, but I was a defendant in a civil eviction case against myself and a housemate for unpaid rent. A third tenant had skipped and hadn't paid her rent, and at the time we weren't aware that, as tenants, all three of us were liable for the combined rent. We were young and dumb, generally pretty poor, and had made terrible mistakes. I don't know about the other guy, but everything since then has been above the board renting wise for myself. Haven't had an issue with rent since. The house was in a terrible state, for what it's worth, and so we weren't too attached to the idea of continuing to be there. The whole thing was sketch as fuck. Indeed, on the day, we point out pretty quickly that we'd be happy to vacate within 48 hours. In her opening remarks, the landlord turns on the waterworks and says that she just wants us gone as quickly as possible, even though she was absolutely going to go for the unpaid rent and try to put us on the state tenant blacklist. So when our state provided legal aid opens and just throws procedural roadblock after roadblock in the way, starting with, indeed, questioning if we were even tenants, because there wasn't a signed lease or anything of that nature, and arguing that we weren't tenants, but instead renting the rooms themselves was pretty key to the plan. The judge cut her off, pointed out that we didn't want to be there, and that the landlord just wanted us gone. It was late in the day, the court was running late, so she threw the case out without awarding damages or eviction, and ordered us to vacate within 72 hours, giving both sides what they claimed to have wanted. Throw away for various reasons, including the controversial nature of civil asset forfeiture at the moment. I work for my state seizing assets using civil asset forfeiture laws. In this case, after an extensive wire investigation which resulted in dozens of convictions, I was attempting to forfeit the target's vehicle. His baby mama was attempting to claim the vehicle under a statutory innocent owner defense. The target had pled guilty to multiple drug charges. The woman's claim was that she purchased the vehicle after the target was arrested, and before he was convicted, had no knowledge of his use of the vehicle, and was never charged herself. During the investigation, the vehicle was seized, but we never found the title. Anyway, I put on my case, showing dozens of photographs of the target using the car to make deliveries. In my state, using a vehicle to make deliveries can be a basis for forfeiture. The affiants testified that during the several months of the investigation, they never saw the woman in or near the vehicle. Woman gets on the stand and says her and target went to a notary on a certain date, let's say July 1st, 2014, because I can't remember anymore. She says target arrived in the vehicle on that date and they both signed the title in front of the notary. Problem is that the target and the vehicle were both in state custody from, let's say, October 1st, 2013, to the date of trial. Also, the notary refused to testify citing his safety, but told me off the record that the target's friend threatened him into forging the title on July 1st, 2014. I had subpoenaed the notary, but was only planning to call him on rebuttal, if necessary. After cross, counsel asked for a sidebar and requested to withdraw his action or his representation as he felt his client lied to him and he could no longer in good faith represent her. He should have found this discrepancy prior to trial if he had done his due diligence, but that's not my concern. The judge granted the voluntary dismissal of woman's claim and granted forfeiture. But when I was in school, several guys I was friends with all decided to go in on a house together. At first it was great big house, no shitty apartment, and we each only pays $308/mo for rent and utilities. Well, we decided to open an account we could all deposit into for rent. In retrospect, a bad idea. Anyway, we all go to school, come back, and notice one roommate's stuff is all gone. Later we notice that all the money in the account was gone. He took it all and ran. Well, we call him and Manger to get him on the phone. We try to be amicable about it and work something out, except her never paid anything. So we try again, same result. At this point I went and sued him in small claims court. Our day comes and we all show up in suits. He is in a dirty sweatshirt and sweatpants. Anyway, things are very much going our way, and as a last ditch attempt here brings up the fact one roommate wasn't present to sign the lease. I had signed it, with his permission, for him. Well, the judge happens to deal with property law normally, so he asks my roommate if I had permission to sign for him, which he responds that yes, I did have permission. So the judge informs the ex-roommate we are using that with permission. Signing for someone is perfectly legal. After that there really wasn't any argument and we won. Not a lawyer. Story of a lawsuit my family was involved in. My mother and aunt started a country-style wedding venue last year, and it is in a very rural but residential area. Lots of neighbors to the property. It's a beautiful place with open fields and a pond, about 30 acres or so. Most of these neighbors likely used to use the property for their own purposes before my family began leasing it. The neighbors were upset for multiple reasons, not being able to freely use the property anymore, noise, too many cars, to name a few. Quite a few residents got together and co-signed a lawsuit on the venue to prevent it from being rezoned from agricultural to commercial. They said they didn't want hundreds of cars and loud music, but also they didn't like that commercial zoning would allow for things like festivals, racetracks, and many other large ventures in the future, even though that would never happen. We just needed the commercial zoning to increase the maximum amount of cars allowed on the property. They demanded that it remain agricultural, and it looked like they might get their way, to which my mother argued, alright, we'll just turn it into an actual farm, and we will raise pigs right next to the road, where everyone can see it. They didn't like that, and eventually their attempts fell through. The person who spearheaded the lawsuit actually ended up attending a wedding there a short time later, and according to my mother, he seemed to be having a wonderful time. Okay, I'm not a lawyer, but this is a good one point. So I've worked at a Wild West theme park in Ocean City, Maryland for years. We use real guns but shoot blanks. And a lot of us use our own personal pistols, since the revolvers that have been in the park since 1959 are a little worn out. So one of my co-workers is headed home after work, and he gets pulled over because his taglight is out. Cop sees the holsters in the very back of his SUV and asks if there are any guns in the car, to which my buddy confirmed there were 5 guns. Next thing you know, he's being hauled out to the car and spends the night in jail. 5 counts of illegal transportation of a firearm. Pre-trial they offer a plea bargain. He has to soft his choice 3 of his 5 pistols for confiscation. He tells them to fuck off and goes to trial. Jury selection and witness statements take nearly all day. Then the prosecutor is making his closing statements and says, "Ladies, gentlemen of the jury, the state concedes the fact that the defendant was transporting the firearms in lockbox in accordance with the law, and that the defendant did not have any live ammunition in the vehicle." What the state is arguing is that the defendant had no legal purpose for which to be transporting firearms at all in the state of Maryland. I'm now going to read you the exact law pertaining to legal reasons to transport a firearm in Maryland. 1. Transporting to or from a firearm dealer. 2. Transporting to or from a gun range. 3. Transporting to or from hunting. 4. Transporting to or from a public or private performance. At that point there was an awkward pause as it sunk into everyone, including the prosecutor, that the whole case was bullshit. He stammered onto a few other valid reasons before ending his closing argument. It took the jury less than 10 minutes to acquit on all charges. The prosecutor retired immediately after this case and is now a defense attorney. IAAL, although it was not a major point, I once had opposing counsel lay down a line of questioning that led a witness to claim that he hadn't attended an event in February because it was a certain religious holiday. The religious holiday in question always occurs in the fall. It wasn't critical to the case, but it made clear that the guy was a giant liar and that all of the other stuff he claimed should be considered unreliable, which was, I think, critical to the case. On another file, a person who owed our client money was receiving damages from a lawsuit, and we were in court attempting to seize the damages to pay back out client. When the file started, the lawyers had some initial talks in which it was discussed that our client would get most of the proceeds, less $15,000, that the other party would get to keep. However, after some review, the lawyer for the other party decided we weren't entitled to anything, which resulted in the court proceeding. The proceeding was on affidavits, meaning the judge swore written statements, not oral testimony. We spent quite a bit of time doing legal research and preparing arguments for all of the legal bases why our client should be entitled to seize the funds. When we subsequently received the other party's materials, his affidavit, which the lawyer obviously prepared, had a brief throwaway line about how they had initially agreed that we would receive the award less $15,000. They went on to argue all the legal bases, in their view, why our client was not entitled to seize the funds. When the judge walked in at the hearing, the first thing she did was turn to the other party's lawyer and say, "I've read the material. It seems to me that your client agreed to settle this matter for $15,000. Why are we here?" 2 hours of argument later, in which they didn't even really make an attempt to explain why the settlement was invalid, and the judge quickly ruled that we were entitled to receive the amount initially agreed upon. Total damages less $15,000. Of course, we were also awarded costs, which is typical here. So at the end of the day, the other party ended up with pretty much nothing. This was not an error by the lawyer on the other side, but by his client. Years ago I was a prosecutor in the DA's office of a small county in PA. I had a case where the defendant was facing charges for burglary. It wasn't the world's greatest case as far as the evidence went, but he was in jail because he had also violated parole from a previous charge. He was looking at couple of years imprisonment if he was convicted of the burglary charges, so his lawyer was gearing up for trial point. So I'm not sure how it happened, but some paperwork was sent out that had the incorrect charges on them, drug possession and similar offenses. A week or two later I get a letter at the office from the county prison. It was handwritten and signed by the defendant, and it said something like these charges are bullshit. I didn't have any drugs. All I did was break into that motherfucker's house. Pretrial conferences were the next day and I knew the public defender representing him was going to have it listed for trial. I saw him and said, look what I got in the mail yesterday, and handed him a copy. He rolled his eyes, cursed for a few moments, and said, yeah, we'll be listing this for a guilty plea, TL, DL. Criminal defendant provided a written confession of a crime to prosecutor because of a paperwork error. Not a lawyer, but someone tried to sue my parents over the house they bought from them. The massive pine tree in the backyard had grown its roots into the sewage pipes, which would block them and cause raw sewage to flood the basement. After cleaning it up a handful of times, my dad learned that just dumping an entire bottle of drain cleaner down the sewage hole in the basement once a month would keep it clear and prevent further problems. Yeah, not the ideal fix, but short of spending thousands of dollars to tear up all the sewage lines, it kept the place in good condition. When they were selling the place, he pointed it out to the potential buyer and instructed them on how to keep the pipes clear. Buyer was fine with it and proceeded with the purchase of the house. A couple months later, my parents are contacted by a lawyer stating that there are massive issues with the plumbing that weren't addressed in the contract to buy the house. The new homeowners claimed they weren't informed and wanted all their money back for this false advertisement. My parents pointed to the contract where it stated the house was sold as is, that is, you accept the house and all its flukes, whether specifically addressed or not in the contract. The lawsuit was dropped immediately. Even with that, my parents had tried to explain the problems and how to prevent them. They weren't looking to screw anyone over. But the new homeowners neglected to take it seriously and found their basement flooded with a couple feet of raw sewage. Bonus points. My parents sold the house for $100K the month prior to the housing bubble burst. After the burst, the new owners couldn't sell it for even $20K. They were stuck with a $100K mortgage and expensive sewage problems. Probably wanted to get their money back so they could go buy a nice house for a fraction of the price. In the end, my parents made out like bandits. So, I'm not a lawyer, but in high school we had a mock trial as a project. While reading about the Salem witch trials, a student was accused of being a witch, and the prosecution team had to prove why she was a witch, and a defense had to defend her. There was also a team of jurors, and people could be called on as witnesses. The prosecution presented some evidence, I cannot remember, which wasn't the greatest, but was not refuted by the defense. The defense relied very heavily on the testimony of a single character witness. This character witness vouched for the student and presented himself as a very devout man who attended church regularly. There was a final section where defense and prosecutors were allowed to clarify any evidence or re-interview witnesses. Defense decides to ask some reiterative questions of their main character witness. So, the defense at the end of this second testimony says, "So Mr. Jefferson, I just want everyone here to know that you are a good Puritan man and you attend church annually. Is this correct?" Mr. Jefferson replies, "Yes, this is correct." Defense then sits down. Immediately, I, part of the prosecution team, ask the judge to make a clarification. Judge grants my request, and I proceed to inform the court that if Mr. Jefferson attended church annually, he is in fact a rather poor Puritan man, and his sloth behavior reflected onto his testimony about the defendant. Since this closing arguments were next, the judge did not allow the defense to correct their testimony. Defendant was found guilty and summarily hanged. IIL we were being sued by a former client, FC representing herself pro SE, claiming our fees were too high, contingency fee case, because the judge in the underlying case took almost 120 days to make a decision. to grant a motion for summary judgment I filed. Our fee agreement jumped up from 35% to 40%, costing the client $300K. FC alleged that she couldn't get an attorney to take the case because other attorneys in my firm were prominent individuals in the community. FC then asked, in open court, for an extension of time to obtain an attorney to oppose our motion to dismiss. After being granted a continuance of 60 days to try to get an attorney, which was 30 days less than requested, FC accused the judge of being on the take and that we had bribed the judge to give her a shorter period of time to oppose the motion for continuance that had just been asked for the first time in open court, including saying that everyone knows you and every other judge in this state are on the take. After making a record and giving FC an opportunity to walk back the statement, which she refused to do, the judge said, "You know what? I'm changing my mind. You already missed your deadlines, and under local rule 30th, a request for continuance must be made before the response is due. I'm going to use my inherent powers to manage my docket and grant Ciberno's motion to dismiss." Late to the game, but I'm a lawyer. Was working for a time as a prosecutor in a small county. There was an effort to clean up parts of town, and we had a nuisance bar task force to accomplish a part of that goal. By statute, we have the ability to file injunctions to close down bars that historically have been problems. One such bar was the home of purported drug use, fights and a shooting point. Since the county was small, none of the local attorneys saw such an action before. Therefore, they had no idea how to deal with it. So the owner enlisted the services of a frequent customer, a cantankerous old bastard who wasn't very good. During the trial he kept throwing in little insults at me and was generally not civil, all the while stating that we had no evidence of drug activity and that the bar was safe. We countered that the owner failed to keep unruly people out of her bar and that she failed to ban problem patrons. On the second day of trial, he produces a banned patron book, not disclosed prior to trial, but that was another story, and proudly gave it to the judge. He puffed his chest and asserted that she maintained a clean and safe bar. Then the judge starts reading the book. Mr. A, cocaine Mr. B, fighting Mr. C, cocaine Mrs. D, drugs. It was apparent he didn't read his own evidence. Essentially proved the bar was a drug den. We won. The following was from a criminal trial for bank fraud. The defendant was accused of using multiple stolen names/SSN to open unsecured lines of credit at financial institutions. He would then transfer money from account to account and deposit large, forged checks to artificially increase balances and money available to withdraw. Ultimately, he would walk up to a drive-through ATM at night to withdraw money, or use a debit card to buy postal money orders, or write checks against the accounts. One check was to a young lady on the other coast, who we contacted and interviewed. She said that she met the defendant at a bar and they communicated frequently by phone, and met occasionally when he was out there. She had run into financial problems and sent out a request to friends and family for money, and he had sent her a check from one of the bogus accounts. It appears that the defendant's story was that a friend owed him money and sent the check to the girl at his request. The defendant was married, and I guess he wanted to prove to his wife that he wasn't actually talking to some young lady nightly for several months. So on cross-examination, his attorney asked what phone number she used to call the defendant. She had to get the bailiff to retrieve her phone, powered it on, and then read off the number, which was one of the numbers used to create two of the bogus accounts. Awkward. No further questions, Your Honor. There was plenty of other evidence linking this guy to the crime, fingerprints on applications and deposit slips, video of him and his daughter in line at the PO on 3 separate occasions when money orders were purchased, bank statements found at his house, etc. But this sure didn't help his case. This is a thoroughly unsexy story, but maybe some of the lawyers will appreciate it. I had a trial on an employment contract. My client was the employer, and the issue was what was meant by a certain term in the employee's contract. If it went our way, we'd owe the employee $X, and if it went the other way, we'd owe the employee 5 or 10 times $X. So opposing counsel asked some question about the contract that was objectionable. I don't even remember what it was at this point, but I stand up and object. The judge calls us over to the bench, and I explain that under federal rule of evidence whatever, opposing counsel can't ask that. Opposing counsel argues back, and the judge hems and haws. He's clearly not sure what the right ruling is, so we keep arguing, and I somehow convince opposing counsel. Now opposing counsel is saying he's right, Your Honor, and the judge is still saying I'm not sure, but saying things that make it seem like he's going to overrule my objection. An objection that is now unopposed. Opposing counsel wound up withdrawing his question. Or maybe we were together able to convince the judge to sustain my objection. It's been a while and I don't remember ultimately. It was not an important question, and I assume opposing counsel figured he'd rather withdraw it than take a chance that the bad question could be grounds for appeal down the road. My guess is it would have been harmless error anyway, but why take that chance? I'm not a lawyer, and this really has nothing to do with this post other than being court related points. So, when I was 19 I got my first speeding ticket for going 80 in a 55 on 590 in Rochester, New York. I was coming from MCC and going back toward the east part of Monroe County where I lived. A state trooper pulled me over. They had speed traps set up that day and was issued a ticket to appear in Brighton Town Court. Anyways, I got home and told my mom about it. She claims I bragged about how it would be reduced because it was a first offense and just be a moving violation such as running a red light. She wanted to teach me a lesson since she thought I was bragging and didn't see it as a big deal. She works at a nursing home and her boss's wife, at the time, was like an assistant DA or something like that. She told her boss about it, and he got her in contact with his wife. The wife set it up with the judge that I would get the maximum fine and maximum points on my license when I went to court. That I would be blindsided and taught a lesson point, so I go to court and yada. I get home, and my mom asks what happened. I go, just like I told you, they reduced it, and I got a $90 fine, plus the court fee New York tax on apostrophe. She was so shocked. Come to find out the judge that was supposed to hear my case was Jewish, and it was Jewish holiday that day. What was supposed to happen never got relayed to the judge presiding that day. I still love giving my mom shit about that to this day. Tried to pull one over on me and it backfired. Haha. Not a lawyer, but work in legal intelligence for a law firm, and I'm occasionally called to attend trial to give evidence. We mostly defend fraudulent injury claims and that sort of thing. In this particular case, we didn't really have a particularly great defense other than some tenuous Facebook evidence, which the claimant tried to explain away as a hacked account anyway. The claimant was questioned on his version of events. Wasn't particularly convincing, but again, at best we had a 50/50 chance of success. That was until he was sent out, and his wife took the stand for questioning as his witness. She basically described a completely different version of events, and then you could see in her eyes the exact moment where the penny drops, and she realizes she's faked up their story. She said she wasn't feeling well. Judge said she could have a break to get some water, and she then stood up and fainted. Now, the judge and both members of counsel treated this as legit and called for medical assistance, but we all knew it was bullshit. She eventually woke up, gasping for air about 5 minutes later, as if she'd woken up from a Freddy Krueger dream. At this point we were sent away for a lunch break, but when we came back the claimant's counsel told us that they had suddenly decided to withdraw their claim. I annually was on a jury for a robbery case a few years ago. Jury selection was interesting. The case was in regards to one of several alleged smash and grabs performed by the defendant. He was accused of smashing the passenger windows of parallel parked cars, just as women got into the vehicle, grabbing whatever he could reach, and then running to his car and racing off. He was caught in the act of the same MO. Our case was about an earlier smash and grab. This is all relevant to jury selection, because of who was selected to be on the jury. Everyone that was on the jury had either been the victim of, or knew a victim of armed robbery, lost someone to a botched armed robbery, or was the victim of car theft/vandalism. I fell into the last category. My car had been vandalized severely one night while I was in college. It became clear during jury selection that it was the defendant pushing to get a jury loaded with victims/friends of victims, and not the prosecution, who was pushing for an ethnic and gender diverse jury. I suspect the prosecution wanted diversity to cover their butts in case this guy tried an appeal. We found him guilty pretty quickly despite some poorly written jury instructions that almost caused a mistrial. Our instructions stated that we could only find him guilty of both armed and unarmed robbery instead of either/or. The jury foreman was extremely hesitant to ask for clarification and a sizable portion of the jury refused to vote with instructions as written. Not a lawyer, but I was a security officer for 8 years and seen my fair share of court time. I was once pulled as a witness to a domestic/custody case I didn't even have a hand in besides dispatching the cops to the location, and that was it. What happened? Mother and father were divorced, but having dinner at a restaurant on my property. During the dinner the mother passed a help me note to the server, who told us, "Security." I dispatch a few officers and call the cops. They arrive after the father had left, speak with the mother. She didn't feel safe. Fast forward about 10 months and this old guy who seemed a few crayons short of a full pack comes in and asks if I dealt with the issue the mother had. I said I dispatched the cops and searched property for the father, but beyond that, nothing. He introduced himself then as her lawyer and subpoenaed me to be a witness for their case. A month later, I show up to court, wondering what in the hell I'm doing there, unable to get anyone to listen, even being introduced by the mother's lawyer to the father's lawyers, and no further interaction, knowing very well that I probably wasn't the best witness to this. I take my seat and listen to this case, which I thought would be domestic abuse, go directly into child custody. The father begins to list everything from the mother using drugs, to drinking, to her supervised visitation rules not being followed. The mother testifies claiming she was running a safe household, incriminating herself when she told the judge that she'd spend her time in the front of the house during supervised visitation, while her child and grandparents were in the back. She turned on the waterworks to try and convince everyone that she was a fit mother and just wanted her kid, that she didn't do any drugs or drink in front of the child, and that should account for something. The judge didn't even say 2 words before barring her from contact with the child and granted full custody to the father. Her lawyer came up to me afterward and said, "We tried. Thanks for coming." I shrugged, mentioned that I just got paid for a few hours of listening to a very intriguing case. I was actually very annoyed I had wasted gas and time for nothing, and promptly left before I decided to chew him out. Ironical, but one of my best friends was going through a custody hearing that I was there every step of the way for, including the night her ex didn't bring their daughter home and told boyfriend he was keeping her. She called the cops. They arrived 18 hours later, needing to be called 3 times, and did nothing. So ex is suing for full custody, basically on the grounds that he has money, thus will be a better parent, despite the fact that he had just told her other kid, who he raised from infancy, but isn't the father of, that she wouldn't be coming to see him anymore because he's no longer her dad. So he's suing for full custody on the grounds of money, but the judge literally has to court order his financials and address from him because he was unwilling to expose those. Literally gave boyfriend and judge a PO box. The judge discovered he was making way more than he told boyfriend. He also fully admitted, basically offered up without question, that he took and kept their daughter despite their previous arrangement and did not intend to further parent the 7-year-old girl that wasn't his. The judge basically called him a faking idiot, giving the court a PO box, lying about his finances, literally abandoning the sister because he decided she's not his anymore despite 7 years of parenting her, and admitting to kidnapping the toddler. Boyfriend was awarded over double what she was countersuing for child support, which rich daddy never paid before, forcing boyfriend to at times work 3 jobs because this was literally trying to make her unable to take care of her kids so he could have the toddler. She got full custody. She still lets him see her, but the judge warned him what trying that cheat again would mean, and he doesn't get to see her near as often as before. I'm not a lawyer, but I worked very closely with my lawyer in crafting our strategy when I was sued by an ex-supplier. When I switched to a new supplier, they claimed that I still had possession of 3 pieces of equipment and were suing me for the cost of the equipment, plus the daily rental rate, which was significant since over a year had gone by until we met in court. We tried to settle multiple times, offering to pay for one of the pieces, but they refused every time, wanting the full amount. That was fine with me. I didn't have their equipment, but I was following my lawyer's advice to pay a small amount to make it all go away, but I felt like if I paid for one piece, that was the same as admitting that they were right in claiming that I had stolen all of them. So I was glad to face them in court. It was clear in the courtroom that they were completely unprepared for this, and my lawyer started destroying their case immediately by pointing out how poor their inventory control and invoicing system was. Finally, the branch manager took the stand. How many of those pieces of equipment do you have in your inventory? I'm not sure. How often do you do inventory? 2 or 3 times a year. When was the last time you did inventory? A few months ago. How many did you have then? I'm not sure. Do you ever repurpose these pieces for other users or repurpose others for this use? Yes. How many have you done that with this year? I'm not sure. At this point, the judge spoke up, saying, are you saying that you have no idea how many pieces you have, but you are certain that the defendant has 3 of them? Yes. The judge didn't look convinced, but let the trial play out. In the end, she severely admonished the other side for their poor record keeping, saying she's never seen a major company with such terrible accounting and inventory control systems. We won the case, and they had to pay the legal fees. Not a lawyer yet, but I've interned just about everywhere I can. As an intern at my local PD's office, we got sent to observe PFA hearings. For those not from PA, a PFA is a protection from abuse order. Kind of like a restraining order, you know. This story involves no lawyers. It's 2 people representing themselves pro se. Anyway, we sat through all the hearings. There's usually about 20 in a day. The final pair comes up, former boyfriend and girlfriend. She's seeking an order against him. She testifies that he's abusive and threatening towards her, but she's conflicted because the previous week they went out and had a good time, but after that he was mean again. Okay, now the guy is up to testify, but he wants to question her instead of testifying for himself. The judge allows it, cautioning him. He questions her, and she admits that she invited him out. He paid for everything, and then the final question comes up for that night. The guy puts his head down a bit, gets his finger guns ready, and asks her, did we have sex? She admitted to it, and holding back a laugh, the judge dismissed the case. On his way out, the guy turns to me and says, beat that sheet up. That's how you do it. I've seen dozens of trials and hundreds of hearings, but that was the single best cross-examination I have ever witnessed. The sheer confidence and pride of that guy gets me every time I think about it. Hadn't his social neighbor I don't like attack an officer in front of me was called as a witness. The hearing was to determine whether she had attacked the officer. She turns up in her pajamas with no representation, adamant she didn't do it. I provided plenty of evidence to our side solicitor. During a recess, I told the solicitor to check out her Facebook. She was bragging about getting away with it and everyone else was a lying cunt face, right? In the doc. Eventually the solicitor informs the judges what's going on and hearing was postponed to Halloween. When the hearing restarts on Halloween, she gets into the room now dressed in her old school uniform. First matters first, she yells, what's he doing here? About myself, before yelling at the judges that this isn't fair. Now though she has cheapo chav friend representing her, friend is very savvy with the legalese. My client might have hit the officer cause she felt provoked cause she was trying to stop her music now, and that's not the right thing to do. The judge humored them and asked what the right thing to do is. Just because you can't faking ignore it don't make it right to take her stuff. Instant guilty verdict. Fine given an ASPO and benefits stopped for a few weeks. So not much of a punishment, but her would-be lawyer literally threw her under the bus. Not a lawyer, but was on a jury once when this happened. It was a very basic criminal assault case. The defendant allegedly beat up a girl after a shift at work. The prosecutors were very clear that they were trying to prove that the defendant attacked the victim and that bodily harm was done. Both lawyers questioned the victim, who claimed she was sucker punched and beat while she was down. They brought up witnesses who made similar, though less specific claims. They brought up the arresting officer, who reiterated the stories we had already heard. And then they brought the defendant up to the stand last, and she began explaining the situation. She explained that the victim was being annoying all night and that she had had enough. She explained that the victim took her earrings out, which signaled to the defendant that she wanted a fight. And then she explained how they went at it and bragged about how she won the fight. You could see the lawyer for the defense deflate immediately. In closing arguments, the prosecution reiterated that all they had to prove is that the defendant attacked the victim and caused bodily harm, and, conflicting accounts aside, every party, including the defendant herself, had admitted to that. The defense had very little to say after that point. The most frustrating part of this process was deliberating. The other 5 people in the room wanted to let her off because the victim had it coming. This idea was entirely based on the defendant's claims and nothing else. In the end, I explained the charge again and reiterated how she admitted that she had done just that, and we all voted guilty. The judge came in afterwards to answer questions and agreed with our decision 100%. The judge explained further that case never really should have gone to court, but the defendant really wanted it to. She ended up with probation and community service. Not a lawyer, but I once watched a court session between 2 lawyer brothers. Let me shorten that gigantic story for you. The younger brother was trying to convince the judge that the older brother was unreliable and mentally unstable because he was lying about having a condition. He referred to it as electromagnetic hypersensitivity, basically an allergy to electricity. Before the session began, everyone's cell phones and electronics were gathered, and lights were turned off. Otherwise the courtroom was unbearable for the older brother. During the interrogation, the young brother first tried to trick the older one by giving him his cell phone, which he secretly kept in his pocket. However, he took out the battery before, and the older one realized that pretty quickly. But then, the younger one asked him if he had something in his pocket. He reaches in there and finds a cell phone battery. Turns out, the younger one hired an assistant to implant that battery on his pocket over 90 minutes before, and obviously he hadn't noticed. The older brother looked shocked and started furiously blurting assumptions and hatred towards his brother. When he recollected himself, the younger one dismissed him from the interrogation. The session was dismissed shortly after, and the older brother was so ashamed he quit his job at a very large law firm. The firm even had his name in it, and shut himself inside his house. My dad's a lawyer, and just told me this story yesterday. My brother was driving with my dad in the car, and got a ticket for failing to stop for a pedestrian in the crosswalk. It was a BS ticket, because the cops effectively entrapped my brother. My dad went to court, and when the cop testified he didn't say the magic words he needed to say to make his case. This was immediately apparent to both the judge and my dad. The judge looked at my dad shrugged his shoulders, and didn't say anything. The judge shook his head and promptly dismissed the case. Edit. Got a lot of questions. Called my dad, and he explained more. As for the entrapment, the police had stationed a police officer at the very edge of the crosswalk, where it first met the lane of parked cars. The cop wasn't moving, as if she were trying to cross the street, so according to my dad, she wasn't clearly a pedestrian. He said entrapment wasn't really the correct word. As for the magic words, in any case, there are what are called element of the claim in order for the government to establish a case or a plaintiff to proceed on his or her claim to recover. This is the burden of proof for the government or plaintiff. If each element of the charge is not established by the plaintiff, the case should immediately be dismissed at that point. In this particular case, the police officer who testified failed to testify that there was a pedestrian in the crosswalk at the time that the driver went through. Accordingly, the case was dismissed without the need of the defendant to ask any questions or put on any testimony.